Okay, so please check in the WhatsApp group. Okay, so our first speaker for today is Mr. Freddy Sanchez Merino. Hello. He will be talking about types of patents and technology-related agreements, the areas of intellectual property that's covered by different agreements. Mr. Merino is an intellectual property lawyer and a graduate of the University of Havana Law School. Patent and intellectual property management specialist with 11 years of professional and international experience, managing director of Merino and Associates, intellectual property advisor for the Brackenella Chamber of Commerce, senior director of intellectual property at Atlantic Technology Transfer Office, and Director of Innovation and Intellectual Property at Simon Bolivar University, Brackenella, Colombia. Hello, sir, and welcome to our meeting today.
Hello, thank you for having me. My pleasure. Hope you are having a great day. Should I start as of right now? Or?
Yes, you can start now. We have 2 hours starting from now.
Oh, okay. So would you confirm that the presentation is?
Yes, it's going on, yes. On.
Okay, well, again, good morning to everyone. We're going to talk in this first conference about some matters on IP and technology transfer contracts or agreements. We will start talking about some more general aspects of IP in transfer, and then we're gonna, we're going to start from a broader scope, and then we're going to narrow it a little bit. We're going to talk specifically about licenses agreement. We're going to get there. You're going to see why they are perhaps the most important tech transfer agreements, at least the most used ones. Once we get there, you'll understand where we're going to focus our attention on license agreements, but we're going to start from a broader scope so we can understand a couple of things beforehand and a couple of aspects that I think are crucial to understand IP and tech transfer. So the first scene is what we call the IP paradigm in tech transfer. We start from the this triad you have in the screen. Doctrine and academics call this a lot of different ways. They call this like the virtual circle of innovation and IP, or the triad cycle of innovation and IP. So this got a lot of different names, but they all answer to the same concept, which is that in order to have a successful tech transfer, first thing you have to make sure of is the IP ownership. So the first thing is that the owner of the IP have to make sure that he's or she is actually the owner. I think I'm seeing a raised hand. I don't know if we can answer questions directly, which I will be glad to, or if we're going to have a different section for this. But anyway, go ahead. I think it's Abdul. Okay, so he lowered the hand. I don't know. So as I was saying, IP ownership will be done, that first step we gotta make sure of. So IP ownership doesn't work the same way in every legal system. And it certainly doesn't work the same way in all aspects of IP. In all IP mechanisms are not the same. So For instance, there are legal systems in where copyright, for instance, doesn't need any kind of action from the author in order to get protection. So it is sufficient enough with the creation of the work. It's enough for getting protection. So once you code the software or paint the the painting or write the poem or the novel, you are almost immediately the author of that work, and you instantly get all the exclusive rights that comes from copyright. So you don't need registration, and in those cases, there's little you can do to, prove ownership. But on other mechanisms of IP, like patents and like trademarks and designs and trade secrets, for instance, you need to make sure that you are the owner of this IP. This applies through registry mechanisms, for instance, in most legal systems. In order to get a patent, you need to make a patent application. So a successful patent application is proof enough, at least in the first instance, that you are the patent owner. So the patent diploma or the patent certification of ownership is what you need in order to, make a demonstration or to prove that you are the righteous owner of the IP. So ownership would be the first very important step in order to make a successful transfer. Ownership can get complicated if there are more than one author, more than one inventor, or more than one institution involved in the development of the IP or the investigation. For instance, if you belong to a university, if you are a teacher, professor at a university, investigator at a university, or at an investigation center, well, then some presumptions enter into game here, because generally it would be understood that the IP would belong to the institution you work for, but you can put it otherwise on a contract. So you must be very diligent as to understand the relationship between the inventor and the institution this person works for, because not always it's gonna work the same way. IP rights may have been or not transferred to the institution. So that's another thing to have into account when talking about IP ownership. The other thing you have to take into account, it's the possibility of a co-ownership, right? So not always it's gonna be one institution, one person. It may be more than one. So the co-ownership opens a whole new, a lot of scenarios there as to the sharing of the IP. This will depend obviously on the legal system you're working on, but generally speaking, IP is one indivisible subject. So there's no possibility of parting the IP in equal parts, or 50-50 parts, or 30 or 70%. We've seen a lot of contract, those kind of mistakes. A lot of even lawyers, they put it in contracts or in agreements of IP and tech transfer, like parts will own the IP in this matter, and then they proceed to divide the IP like 30-70%, 30 for part A and 70% for part B. This is usually a mistake, because IP as an intangible asset is practically indivisible. So you cannot divide IP, at least not like this. you can divide for sure the benefits of IP exploitation, which is a whole different matter. But IP generates or engenders solidarity kind of property. So the truth is that if you have a co-ownership in IP, all involved parties are going to have the same, the 100% of the IP ownership. That's how it generally works. So that's another thing you have to take into account when talking about IP ownership. So once we have this sorted out, when you have this the IP ownership, you have the first step. You have the first step on your side. So the next thing you have to work on is protection. Okay, protection also doesn't work the same way in all legal systems. There are systems where certain kind of protections are mandatory, or where they aren't. Generally speaking, this is the rule, the general rule. This is because international agreements like TRIPS or like Paris Convention, protection actions will be needed as for patents, utility models, designs, trademarks. So the involved party, it wouldn't be enough for it if it create the IP. It will also be mandatory to take out some actions in order to achieve protections or protection of that IP. So this protection it's carried out before now some administration, some government administration. In Colombia, you have the Industrial Commerce Superintendency. In Spain, you have the patent and trademark offices. You may apply to regional offices. In Iran, I made some research. You have the intellectual property office. So, this protection often proceeds before some government administration, because this is the way it works. IP have been for a long time interpreted in an economic way. So mostly you achieve protection by entering into some kind of agreement with the government. This is part of the social contract theory, interpretation of IP, which in few words works this way. So you enter in an agreement with the government through which the government gives you protection for your IP, and in exchange, you compromise to make this IP public after some term. In the case of patents, for instance, it would be 20 years. In the case of trademarks, like 10 years. Same for utility models. Same for designs. Okay, so this is kind of the approach internationally. So there's no big difference there. And after you have protection, then you can proceed to transfer. And with this, you close the cycle. So the first thing would be IP ownership. Second step, important step, would be protection, and the third and final step would be the transfer. Which in my opinion is the most difficult one, because transfer depends on so many factors, and not only on the individual owning the IP or the institution owning the IP, or the administration in charge of granting protection to that IP, which is. It may be difficult, but it's not as difficult as the transfer, because in transfer intervene market factors, which are most of the time unpredictable. So this makes it very difficult. It's for me the most difficult step of the three, the transfer of the IP. But in any case, this closes the cycle. So how important is transfer? Okay, it depends on some factors. First one is politics. Politics plays a huge role in how important transfer is. So if you are trying to make investigation and research and development sustainable, transfer plays a huge role. Transfer can make investigation and research and development of new products and IP can make sustainable such activities. Because through transfer, you can exploit what you have been investigating on. And with that financial resources, you can reinvest in investigation and create some kind of circle there. Close the circle, close the sustainable gap on investigation, which is a huge problem in a lot of countries. So from that standpoint, transfer is very important. But it depends. For instance, if you are generating, engendering IP and protecting IP as a institution, we have a lot of institutions here in Colombia, for instance, which pursue the patent only for the ranking, investigation ranking. They are not really interested in exploiting the patent from an economical standpoint. So for them, for this institution, transfer is not really that important. So which is why I told you that it depends on the role that you think transfer would play on your research and development ecosystem. However, from an international standpoint, transfer is also very important. In fact, as you may see here in this slide, the PCP-IP, which is the Paris Convention for the Protection of Intellectual or Industrial Property, specifically speaking, in its article 5.8.4, establishes that, and also TRIPS do it, that transfer is at least the final intended stage for IP protection. So in a certain way, this gives you the perspective that transfer is like the ultimate goal for which you go through all these first steps. You engender IP, you create IP, you establish lines of investigation, you carry out these investigations, you proceed to the protection of this investigation through patents and through utility models and through integrated circuits and to designs, etc. So you can transfer them at the end of the whole process. Okay, so transfer is a big deal for the administrations that regulate intellectual property at a world or international level. So WIPO, for instance, IP transfer is all for them. Like it's the final goal to achieve the transfer of that IP. Otherwise, IP is not working. So viewed from a very broad mercantile scope, if you are not capable of transferring your IP is not working right. Your IP system is not working right. So it depends on the scope you look at transfer. It may be the ultimate, most important goal of all, or perhaps not that big of a deal. It depends. But there are also, as I said earlier, some factors that interfere or have a big influence in technology transfer. One of them is the practical obligation every IP owner have of exploiting its IP. Most legislations, most IP laws throughout the world include this obligation of exploiting IP. Some of them establish that there's an initial 3 to 4 year period. This may vary from one legal system to another, but at the end, most of legal systems establish an obligation of exploiting IP. The reason for this is that there's an international agreement, in this case, specifically speaking, is the Paris Convention for the Protection of Industrial Property. In this article you see here in the slide, it establishes that a compulsory license may be applied if there is insufficient working or exploitation before the expiration period of 4 years from filing the patent application, or 3 years from the date of grant of the patent. So this it has huge technical implication, as it obliges the IP owner to exploit, economically speaking, the patent. Okay, so it opened in a scenario where the government is allowed to apply a compulsory license. It doesn't happen that often. I could say this, you don't see this, like in practical, in practice, you won't see this ever, but law is there. So it arises as an obligation for IP owners to exploit their IP under the menace that this could happen. So even if it doesn't happen, the law is there. So you're kind of obligated to exploit your IP under the menace of otherwise the government will be allowed to establish a compulsory license. As I said, in practice, it doesn't work that way. We could see that with the vaccines for COVID, for instance. There's a huge movement to make vaccines available, freely available for the generic manufacturers. It won't happen because there's big business for the pharma there. But if governments will want it, they could have applied this article, because most of governments are parties on the PCPIP. So it wouldn't be a big issue from a legal standpoint to apply this article and open the vaccine for everyone to fabricate it and manufacture it. But there's business there, so it makes it complicated. Okay, so as I would say, as I've been saying before, from a legal standpoint, tech transfer is huge at an international level. Proof is, for instance, that TRIPS, I know that many of you are not signatory parts of TRIPS, but it's anyway a very important law, very huge legal binding law, because it includes a lot of countries. So if you are not part of TRIPS, there's still a probability that you enter into business with the country which is. And whenever and whatever in a 2 or more party business, one of them is part of TRIPS, is party of signatory of the TRIPS agreement, then you could be subject to the TRIPS rules. So it's important for you to know what TRIPS stands in the cases of tech transfer. So both Articles 7 and 8 establish that and this is what I have been saying at some point in the last slide, the protection and enforcement of intellectual property rights should contribute to the promotion of technological innovation and to the transfer and dissemination of technology. So this would give you the idea, I mean, the whole objectives of the main objectives of TRIPS, which is one of the more important IP agreements, internationally speaking, is the tech transfer, the transfer of technology. So this serves as basis for what I was saying before, from internationally and generally accepted standpoint of view, the whole point and the whole objective of protecting and creating IP is to transfer it at some point. So this is basically the why we entered into into the IP business, if you can call it that way. And in the principles of TRIPS also, and the point 2 numeral, it establishes that although the main objective of the agreement is to get to the tech transfer, international tech transfer, all parties may be entitled to take the appropriate measures to prevent the abuse of intellectual property by right holders, which are not eager or available to make the transfer of technology, which is applicable at some point in the example I was talking to you about for the vaccine. But also, as I said, there are lots of politics involved here. So most of these articles sometimes don't get applicable into practice because of politics. But the law is there. You can use it, or countries may use it from point to point. So this is just to give a big picture of how it works, tech transfer in the IP paradigm, and how it's legally regulated at an international level in both CPIP and in TRIPS. So now that we have that, we can narrow the scope of the subject of the conference and get to talk about some more specific aspects. So when we're talking about tech transfer, one big deal is the subject of tech transfer, which in other words is what can we transfer as a technology, or what can be part of a tech transfer agreement. First, more important, obviously, inventions. Okay, so inventions is the main subject of a tech transfer deal, and the most generally the most accepted way of protecting an invention is a patent, right? So patents will be at the core of tech transfer deals. Most of tech transfer deals will involve patents in some way. But also there are other forms of protection for inventions, specifically utility models. I know utility models are not accepted in some legal systems, not recognized in all legal systems. There are a lot of legal systems which accept and approve utility model as a figure of protections. For those of you who are not familiarized with utility models, it's a certain kind of patent which provides protection for inventions, same thing as patents, but at a lower, less strict level. Okay, so the requisites for the patent application, which are the inventive level, novelty, and industrial application, are analyzed or examined here from a less rigorous perspective. So the formal examination of utility model, if you may say so, is like softer and more easy than those for patents. So it's a good way to protect gradual innovation and certain improvements for inventions. Okay, so it's effective for that instance. So it's embraced. It has been embraced in a lot of legal systems, which it turns out to be very useful. Also, there are other forms or ways to protect inventions, depending on the legal system, like invention certificates and authorship or invention certificates, depending on the country. Okay, so, but definitely patents as a way of protecting inventions are the core of tech transfer agreements. Okay, so that will be our first example of what is a sectoral subject for the tech transfer agreement. Then we have software. Okay, so software, it may be by itself part of a tech transfer agreement. The thing with software is that you have to be very careful when analyzing the kind of software you are transferring, okay? Because not all softwares may be subject for tech transfer. So nowadays, cloud computing is, it's very popular. It's a very, it's the most, I would believe it's one of the most used forms of computing or software. And it's a very generally used way of getting to clients or to consumers at the end of the consuming chain. So the thing with software in the cloud or software as a service, which is, as we commonly know it, is that software as a service, as its own name indicates, it is not a tech transfer subject. It is a service subject. So it's a whole different kind of agreement there. It's a whole different contract. Whenever there's a software as a service involved in the transaction, you have to be very careful, because if the transfer only involves this software, then you may not speak about tech transfer. It is a service you are providing. So the contract you have to use there is access to cloud service, but not a tech transfer contract. I don't know if I made myself clear there, but to sum it up, when you're talking about software as the only matter within a tech transfer operation, you have to be very careful and analyze and identify which kind of software you are using, because if the software you're talking about, the software you're working with, is a software as a service, then it is not a tech transfer. It is a service agreement you have to use there. There's no tech transfer there, because the consumer, one of the parties in the agreement, will not receive the software in any matter, in any way. So it wouldn't be licensed there. The software is not going to be handed over to it. So there's no license, there's no assignment of the software. There's nothing there. The software will remain in the servers of the provider. So the only thing you have there is a service agreement. So that's one example of how careful you have to be when talking about software in tech transfer, when the subject is software alone, because there are many examples in which you have to transfer the patent, and alongside the patent you have a software. Well, in those cases, you don't have to worry much about it, because if the software is software as a service, then you can get into you can include it into the tech transfer agreement as the technical assistance or something else. You don't have to worry much of the kind of agreement you are using, because the patent will definitely use tech transfer. Okay, but software, you have to be very more careful around it. So another asset that you can transfer as a subject of tech transfer agreements is the trade secret. Okay, trade secret is a very effective way to protect patentable or not matter in both scenarios. Okay, so if you cannot access to the patent system because of the nature of the invention, well, you can use trade secret. But also, if you can access to the patent system, but it's not in your interest because of this and that, then you can use trade secret as well. And in both cases, you can transfer trade secret as part of a tech transfer agreement. But as in software, you have to be also very careful there, because when you're talking about when you're talking about the knowledge, which is the core of a trade secret, is knowledge. You know, it's information that you cannot make publicly available, which is what it makes information vulnerable in this case. So trade secret, which is basically information, it's complicated to license it. So in terms of technical drafting and drafting of contracts, you know, from a legal standpoint, is at a certain point, it may be incorrect to talk about trade secret licensing. There are a lot of authors that use these terms. I don't say it's totally wrong to do it, because it is in fact accepted, including among lawyers, to use trade secret licensing as a term. But when you talk about IP, I'm sure you know this, but I'm going to mention it anyways. When you talk about IP rights, you're talking about two types of rights. You know, you have the positive rights, which are the rights that you as an owner are capable of execute. You know, use the trademark, use the patent to fabricate or commercialize or manufacture or use the invention, etc. These are the positive rights. And then you have the negative rights, which you know, in some legal systems are known as ius prohibiendi. And this ius prohibiendi, which is Latin from the right to prohibit, you know, the right to you know, deny, stands for those negative rights that the owner of the IP have in order to impede, stop third parties from using its IP. So when you're talking about knowledge and trade secrets, these negative rights are non-existent. They are not applicable, because you cannot forbid a third party to get the same knowledge as you and to use it as they find fit. So the owner of a trade secret doesn't have these negative rights, at least not with the same extension as the patent owner have, or may be entitled to. You can certainly, you know, forbid a third party from make your trade secret publicly available, but you cannot forbid him to get to the same knowledge as you did. So that can turn out to be very complicated in terms of legal terms to establish as a license. So in trade secret, it works best to talk about assignment, which have a very deep legal and non-legal implications. We're going to get there, but it was just an annotation I had to make. So the other thing you have to take into account when talking about trade secrets is the fact that trade secrets can at some point enter in contradiction with the patent systems. Why? Because well, they function like quite in opposite ways. Patent systems are public information basically, while trade secrets are the opposite. So in some doctrines, even they're considered to be mutually exclusive. So if you apply patent protection to an invention, there will be little to no possibilities to apply trade secret to the same invention, unless you're talking about protecting through trade secrets part of the information you are not putting into the patent, which is also a common practice. But in most scenarios, these two mechanisms are mutually exclusive. So once you apply one, you cannot apply the other one. So that's one thing you have to take into account. You have to be very careful when considering whether to apply one or the other. Okay, so The other subject, which is possible to transfer through a tech transfer agreement, is copyright. But copyright has also its limitations. You can transfer copyright as part of technical assistance, and you can transfer copyright as part of a manual, of a guide, of operation guide, of manual of instruction. But it can prove to be difficult to transfer or to license, for instance, copyright. Okay, as tech transfer deal. And let me clarify that, because generally speaking, copyright is perfect subject matter of licensing, but within a tech transfer deal, copyright often plays a secondary role. Okay, so let's talk about some of the IP potential issues that can arise in tech transfer. So here we have some aspects you have to take into consideration when transferring IP. The first of all is granted or requested patents. When we talk about IP, and I said it before in the slide, in the aforementioned slide, patents play a significant role. So patents may often be at the core of tech transfer. So when talking about patents, you have to be very clear if the patent is granted or requested. You know, if it's in the filing process still of the patent, or if the patent have been already granted. This plays a huge role in the kind of deal you use, and the way you put the technical issues in this deal, the way you draft the contract. It plays a huge role, because this can make the contract aleatory or not. For instance, when speaking of a license, if the patent hasn't been granted yet, then you will have an aleatory license there, okay, which is important, because the whole contract will be subject to the condition that the patent have to be granted. Otherwise, such contract will be ineffective, can be declared void or null, depends on the legal system and the figure you use, but it would, you know, lose all legal effects. The patent doesn't get granted. So that's an important issue to analyze or look to when signing IP deals. You may also have to pay attention to what the law establishes about it. In some legal systems, you can license and transfer patents which aren't granted yet. This is something you have to look at. For instance, in Latin America, we have a lot of countries that can and may, and where owners can and may license patents which are not yet granted. Well, you know, this is in order to broaden the possibilities of commercialization of IP. The fact that you don't have to wait for the office to grant the patent, and you can, you know, move forward with commercialization of the patent ahead of the granting of the patent. But then if the patent isn't granted, you have a big problem there. So you have to be very sure that the patent is going to be granted. The way you file it, that's an important issue also. You know, sometimes you file for a patent under certain claims, but then your office agree to grant the patent, but not for the claims you asked for. So this can be an issue if the agreement you were signing beforehand was based on the concession of certain claims within the patent, and if these claims are not existent or are denied by the IP office, then you have a problem within the negotiation. So all this, you have to be very careful when discussing IP agreements with patent which are not being granted yet. Okay, so that's a very important issue you have to take into consideration. The other thing you have to look to is obligation of registration of the license as a document. You know, in some legal systems, you have an obligation of register your agreement once it's signed. Once your agreement is signed, for all the parties involved, you have to register this agreement at the office, at the same IP office. The patent or the active is granted for third parties effects. So, for instance, Peruvian and Colombian and Ecuadorian, Argentinian and Mexican and Brazilian law establish that a patent license have to be registered or inscripted within the IP office of the country in order to be effective for third parties, which means that if you don't register your agreement, you cannot use it as proof in opposition to third-party claims. Okay, so in some countries, there's an obligation of registration. And if you're thinking about international commercialization of your IP, you have to take this into account, because even if within your legal system, there's no obligation of registration of the license agreement, for instance, or the session assignment agreement, which is another obligation here in Latin America, probably for the other party you are involved with in the agreement, this obligation will be mandatory. So you have to take this as part of the considerations beforehand in the IP negotiation. Another thing you have to take into consideration is the anti-competitive practices, which are even regulated by TRIPS Article 31L. Whenever you are talking about exploitation of IP, you have to be very careful. Those activities you're carrying out are not to be considered as anti-competitive practices. This is translated to a monopoly or trust, whatever you want to call it. Although IP grants this kind of monopolies, you know, you have to be very clear that IP grants legal monopolies, which is different of economic monopolies. Okay, so we are talking about legal monopolies, but not economic monopolies. Economic monopolies are an anomaly of economy. They are avoided by governments. On the other hand, legal monopolies are, you know, recognized. IP laws are a way of showing that legal monopolies are okay. So you can compete in a monopolistic way, which is a very exquisite term to somehow propose that you can have a micro monopoly, but not a huge monopoly within economy. And you can compete with other parties, which also will have these micro monopolies. So in any case, you have to be very careful of not being using your IP to anti-competitive practice. It is important. Also, you have to be aware of mandatory licenses. This can be a problem. Most of all, if you are not a big company. If you are a big company like Big Pharma, you are safe, you know, because government wouldn't mess with you. But if you are a relatively small company and you have achieved a huge invention and you have protected through patent, and governments can be dangerous in this sense, because, you know, they can mess with your patent and you know, tell you to don't see the mandatory license. The least you can do is to know how the mandatory license program or mandatory license dynamics work. And you have to be aware that generally mandatory licenses are free. So government wouldn't pay for that. it would make a remuneration, but wouldn't pay you on a royalty basis. They are also non-exclusive. So, so you will be able to continue on the exploitation of the license, which is very important. And they will be, generally speaking, they will be for the whole term of the patent. So in that sense of the you know, the intervention of the rights you own, it can be problematic. But the least you can do is, you know, to get ahead of the whole situation and get to know very well the law you are involved with. So another thing you have to know about is cross license. Cross license is a big deal when talking about IP, because it's very difficult, mainly in very rapid and huge markets like USA and China and European Union. It is very common for third parties to make claims and to you know, get you to trials and establish oppositions for your patent application because you are allegedly infringing some of their rights. This is a very common situation, you know. So one of the most pursued objectives of these parties, of the third parties, is for you to grant them a cross license. And this is one of the most used ways for solving conflicts, legal issues between parties involved in patent litigation. You know, the granting of cross licenses. So you must be aware of how this system works, because it may be almost a certain situation that once you get into an international protection level, like if you get your patent through a PCT application, you may be involved in this kind of situation of a third party making claims that you are infringing their previous exclusive rights. And then this party will be pursuing a cross license. You have to have that very clear, because otherwise you will get into the whole legal conflict around the patent, which can be legally, in terms of time and financially speaking, devastating for you as an inventor, as a company. So it's better if you have clear from the beginning that most probably these third parties looking for a cross license. Once you have it, you can propose it, and you know, litigation will be over in a very short time. So this provides some horizon as to some of the most important legal issues that can arise in tech transfer situations. Okay, so this here provides for some kind of conceptual map, very concrete and narrow conceptual map of different types of IP or tech transfer agreements. Okay, so it is divided in two big branches. The first one is the one we are talking about, IP. And when we talk about IP, we are obviously referring to a protected IP, right? Protected through some kind of a registration mechanism. And on the other hand, we're talking about knowledge transfer, which is takes a huge part in tech transfer deals, but not necessarily subject to some kind of registration mechanism. This is why we have divided into these two microfields. Okay, so when talking about IP, like protected IP to some kind of registration mechanism, you have mainly three types of agreement. The first one is assignment, the second one is sale, and the third one is IP license. So in every one of these three kind of agreements, trademarks and commercial names may be involved as part of a bigger package, like when you have also technology and stuff. But you have to have very clear that if the only thing you're transferring is trademarks and commercial names, then you don't have a tech transfer there, okay? Which is why there's this statement here that goes that it's a trademarks and commercial names, because if you're transferring, it only involves trademarks and commercial names, then you don't have tech transfer there. Okay, so in order to be tech transfer, it have to include some kind of protected IP other than trademarks and commercial names. So we talk about assignment. It is a commonly used way of tech transfer. It involves the renouncing from one party in favor of another one of a set of IP rights. In this case, the original owner, okay, will assign and of course will renounce to its IP exclusive rights. They have a lot of legal implications. However, they are less than what we'll talk about license, which is the more complicated one. We have also the IP sale, okay, which it doesn't necessarily involve assignment of license. This is the case where we talk about, the sale of IP protected objects or active, in which case some figures like exhaustions of right plays important roles there, plays a big part. And we have IP license, which is definitely the start of this play here. License is the main protagonist of the whole tech transfer scenario. It is the most commonly used kind of deal of agreement. It is certainly one of the most profitable one, which is why it is one of the most used by IP owners. Okay, for our standpoint, we will classify license basically into two sub-kinds of license. One where the typical license where one party gives away with certain limitations its IP in exchange of a financial obligation from the other party involved. And then we have the collaboration kind of license, which is the one that we use, for instance, for patent pools and in cross license also, okay? So these are the two kinds, okay, of most commonly used licenses from a financial obligation standpoint. So it can be an exchange license or collaboration license. We're going to get deeper on the differences between license and assignment. A couple of slides ahead. But before that, let's understand a little bit more about knowledge transfer, which is we are short of time. I think I've been too slow on some of the slides, so I'm gonna pace up a little bit. You have like provision of know-how, which is I would say like a permanent figure in a permanent category in all tech transfer deal, whether or not you have IP assignment, because tech transfer can be only about provision of know-how, but it may also provision of know-how may be involved in one of these of the other hand. Like in every IP assignment, sale or license you have, it may be involved, it probably most certainly be involved a provision of know-how, because if you license some technology, it is most than probably that you have to make some provision of know-how in the form of manual of instruction, of technical assistance, etc. So the other way of transferring knowledge is like technical expertise, like studies, formulas, instruction, turnkey contracts, etc. That you provide. You make personal and human resources interchange or exchanges between parties and capacitations and stuff. So these are the two main types or ways of tech transfer deals. So these are the main differences between assignment and license. So the first one and most important is that, generally speaking, they are mutually exclusive. So this is not a rule without exception, of course. There will be some scenarios where you will be able to use a license and then assign some knowledge, attached to that license. But as a rule, you cannot license and assign the same technology. Okay, and in this order plays also a big part, because you can license and then assign, but you cannot do it otherwise, because once you assign, you lose every prerogative you have in order to license. So you should also have this into account when determining which kind of IP transfer you're going to use. Another thing you have to consider when determining whether you will apply assignment or license is the legal implications this will have for the parties. Okay, for instance, there are some limitations that will apply to certain parties involved in the license, or that won't be applicable to assignments. Okay, for instance, if you are the licensee, probably you don't have any legal responsibility as for the technology that has been transferred to you, because the licensor will remain as the IP owner, and therefore it will have all the responsibilities as for maintenance, execution, defense, etc. Okay, but if we are talking about assignment, obviously you became a legal party around the IP. So you will assume all the obligations of the IP, from maintenance to execution to defense of the IP. Okay, so you will gain all the exclusive rights for sure, but also you will be held responsible for the IP infringements and the claims from third parties and legal obligations. So it have huge legal consequence, determining whether you prefer a license or an assignment. Okay, the main difference between license and assignment is the transition of property, which in license it doesn't occur, but then in an assignment it definitely have to occur, because you cannot talk about assignment without the transition of property in a definitive way. Okay, so that would be the main difference between one or the other one. And the other thing is limitations, as I was speaking before. The licensee have a lot of limitations at its disposal, which can be used in order to limit responsibility, as the name indicates, limit responsibility as for the IP. But the assignee, it doesn't have this kind of limitations, just as I explained it a couple of minutes ago. So these are some of the main differences between a license and an assignment. You should take this very very much into consideration before determining whether you're going to use one or the other. So, as I said at the beginning of the presentation, it's my belief that you will make better use of the knowledge of licenses, specifically speaking, than of the assignments, because licenses are more used as tech transfer agreement. They are also more complicated because there's a basic principle here playing a part, which is when we talk about assignment, there is no subsistent obligations or surviving obligations between parties. You know, once the technology has been assigned, there's that. That's final point, period of the relationship there. But license have the characteristic of being a continuum in time between the parties, continuum of obligations, of legal obligations between the parties, which makes it very more complicated than an assignment. So, which is why we're gonna focus on license and some practical and legal aspects of license as an agreement. So, some essential provisions for license agreements are established here in this slide. The first one is you have to be very clear that the licensor will retain the title of the IP which is being licensed. And you will think probably, okay, this is obvious because it wouldn't be a license otherwise. It is not that obvious because in spite of the named parties assigned or gave to the contract, if the content of the contract says it's otherwise, then the court may interpret that it is not a license, but an assignment. I will try to clarify on this. So you're entering into negotiations with the third parties. You have agreed to, license some technology, but in that license agreement, you don't establish that you will retain the title of the technology. You establish that the technology will be licensed for a 20 years period, the whole life of the patent, for instance. You establish that the licensee will get all the rights around the patent. That means use, exploitation, and manufacturing. You also establish that this third party, this licensee, will have the right to sub-license the patent, and that it won't have any limitation on territory, on time, other than the ones established in the law. So this is a license without any limitation, and in spite you have been, despite you have titled the agreement as a license, that's not a license because of its contents. It is an assignment, and a court may interpret it that way. So it is crucial that, other than the title, the content of the agreement indicates in as many ways as possible that you are, in fact, closing a license with the other party, and not an assignment with a different name. Okay, so the essential provisions to establish that it is instead a license, indeed a license, are these ones right here. So the first one is establishing that the licensor will retain the title. So you have to be very clear that you will retain the IP title, and that the licensee only can use this title with certain limitations, okay, which is the second essential provision. Provisions restraining or limiting the transfer as presenting conditions. For instance, time and territory, but also provisions establishing the non-possibility of sub-license, or provisions establishing the payment of royalties or provision, establishing all kinds of limitations you want, like warranties or indemnities, and I don't know, whatever you think is suitable for. Be very clear that this is a license and not an assignment, other than the title of the agreement. It is also very important that you establish provisions limiting actions on the protected matter, because this is one provision that tend to be very confusing for judges. So the fact that you as a licensor give the licensee faculties for protecting the IP that is being transferred tends to be very confusing for judges. Judges won't understand very well why have you give the right to defend your IP to a third party. What other prerogatives or faculties are attached to this right that you have granted to a licensee. So in order to retain the license title, it would be important for you to keep the right to be the one and only one party of defending and executing the IP. Okay, so these are the main three provisions you have to have in your license agreement. Your license agreement cannot lack these three provisions in order to be an undisputed license agreement. So another thing which is important in the license agreement is the independent rights. Okay, so as you all know, industrial property rights can be dismembered, and in a license agreement may be dismembered. It is a very common characteristic of IP rights to be independent between each other. So this is a characteristic you have to take advantage of when talking about licenses. So when you are drafting a license contract, you have to be very clear as to what specific right you are licensing. Okay, so is the manufacturer right, is the selling right, is the using of the technology right, the one you are licensing of? And if you are licensing the three of them, then you have to be very careful, because as I said before, this can be confusing, okay? Because license for, have all the rights can be very near to an assignment agreement. You have to be very careful with the amount of rights you give away. And you also have to be very clear as to the interrelationships that exist between one right and the other one. For instance, you can license the manufacturer right, okay? Sure, but you have to take into consideration that this right generally includes the selling right, because why would someone agree to just manufacture a technology if it won't have the possibility to sell it? That won't be lucrative. You wouldn't get any profits from the manufacturer. On the contrary, it will mean economic losses for this party. Okay, so you have to understand that when you are giving away, when you are licensing the manufacturer right, you are including the selling right. There's no possibility of one without the other. Okay, so you may dismember the rights within the subject of the contract. There's no problem with that, but you have to, be aware that you are licensing both rights and not just one of them. You have to be also very clear on the subject matter determination of the license. This is the most critical provision on the license contract. It's usually also the first provision on the license contract, the license subject matter. And you have to, take care that this subject matter, which is the first provision of the contract, it is not contrary to morality or public order, because that may turn the contract null or void, that it doesn't contain impossible facts legally or factually speaking, okay, you cannot license a perpetual move machine, for example, because that would be factually impossible. Okay, there's no perpetual move machine, so you cannot license such machine. You have to be very careful if you're talking about an aleatory contract, okay, because if you have, for instance, if you have a patent which have been applied for, but it hasn't been granted yet, then the contract will be aleatory, okay? And both parties, this is possible. This is perfectly possible from a legal standpoint. There's no problem with that, but both parties have to be aware of this. Okay, so and the implications this will have if the patent is not granted. So this is important. You know, it changed even the contract classification, the agreement classification, because it would be an aleatory type of license agreement. And you should also have into take into consideration if you're talking about future patents. It's possible in some legal systems it is, in some legal systems it is not. That's the first thing you have to make sure of. You know, if your legal systems allow for you to draft license contracts on future patents and add patents, not that we're not talking here about patents that have been applying to, but they are not granted yet. No, we're talking about patents that haven't even been applied, okay, been solicited before the administration. So we're talking about future patents, like parties agree to, you know, license any future patent they may engender or apply to before the IP office. So these are really in the most specific meaning of the word future patents. So not all legal systems allow this. This is one thing you have to you know, understand very well before signing this kind of agreement. So here we have some licensors obligations. I have paced out because we have 7 minutes left before the questions and answers part of the conference. I don't want to left anything outside the explanation. So some licensors obligations. Well, the first one is not to act against the licensee. This may be obvious, it's not. So you wouldn't want to include any provision on the agreement that may allow the licensor to act against the licensee, because that provision will be declared new beforehand. Okay, so once you license some right, you are explicitly giving away your faculties of acting against the licensee in that matter. Okay, so you might as well put it as some of the obligations of the licensor, because sometimes it's not that clear. Also, you will have, or you will want to include some warrants. This will depend on, I mean, the tightness of the warrants will depend on which party are you within the license agreement. If you are the licensee, then you will want, I'm sorry, a lot of warrants on your behalf. If you are the licensors, then you wouldn't want a lot of warranties, because, you know, warranties doesn't guarantee that the fact which is being under warranty will not happen, but it guarantees that the licensor will take care, financially speaking, of the fact. So if you are the licensor in the agreement, you wouldn't want to give a lot of warranties to the other party. But if you are the licensee, you will want as much warranties as much warrants as possible on your behalf. So some of the warrants, you know, that are unavoidable are these stated here. First one is ownership. You will want an ownership warrant, because this guarantees, of course, that the licensor is indeed the ownership, and not only the ownership, but it has the faculty and the prerogative and the exclusive right to license the right. we were talking at the beginning of the conference of co-ownership. So if you are a co-ownership of a technology, you may not have all the exclusive rights to license the technology. And if you don't have all of the rights, then you cannot warrant ownership to the licensee. Okay, so a warrant in these cases speaks a lot about which exclusive rights you have on the technology you are licensing. So this applies for these scenarios explained here, like third parties, co-ownership, dismember rights, previous patent interference. Okay, so co-ownership is a very important warrant. If you are the licensee, you will want this warrant to be included in the license agreement. If you are the licensor, you will probably have to include it. You will not be very happy about it, but you'll have to include it. So insufficient powers, you have to, this is not as big of a deal as the ownership warrant, but it may be important if you are the licensee to get a warrant that the licensor have enough power to give you a license on the technology, powers as an attributions over the technology. Okay, so no infringement of third parties' rights. This is often confused with the fact that no third parties will raise claims for infringement of the technology. So let's make this very clear. There's no way for anyone to guarantee this won't happen. I mean, this is a right that any third party have. So it may or may not happen. So the warranty is not guaranteeing that this is not going to happen, but that if this happens, then the licensor will take care of it. So there's a difference, because, and this is something important I didn't say before. So once you get a warranty on the contract, you are avoiding for the contract to be declared void. Okay, so for instance, if you do not include the warrant of ownership within the contract, and it turns out that the licensor, it is not the owner of the IP that's been transferred, then that contract may be declared void or null because it has an essential issue in its subject. But if you include a warrant for ownership, then the contract, it is not declared void or null. It will have all the effects until that date, and you can execute the warrant. There's a big difference in law in this matter, okay? So the same thing goes for the infringement of third parties' rights. If you don't include third parties' rights as a warrant, it may be interpreted that you may be in breach of contract and the contract may be terminated for that reason. But if you include a warrant, you are telling the other party that, okay, so I cannot foresee if this is going to happen or not, but if it happens, I'm going to take care of it. And you wouldn't be, legally responsible for that. That's what the warrant is for. Okay, so it is important. And in IP agreements, this is a constant, the no infringement, the indemnity also for third parties' rights infringement. And the patent's technical sufficiency, it may be a very big of a deal as a warranty if you are the licensee. Okay, you wouldn't want for someone, since patents can be, granted and at a TRL 0, 1, 2, I don't know, very low levels of technological readiness level, you may be receiving a patent which is not, even a prototype. And it may be not enough from the technical point of view. So you will want a patent that technically functions, so you may include a warrant if you're a licensee. Most of all, you will want a warrant that guarantees you that the patent is going to work right once you have it, manufactured. So these are some of the most important warrants. when it comes to obligations of the licensor, but it will depend, as I said before, if you are the licensor or the licensee. So another thing you have to include is the improvements. The licensors. You'll have to state in the contract what happens with the inventions improvements. Okay, so will this engender new IP? Which party is going to be the owner of this IP? What happens if the licensor makes these improvements? He will definitely be the IP owner, but is he obligated to transfer these improvements to the licensee? Okay, so these are things you will have to included in the obligations clause. So if you are the licensee, you will definitely want this included. Okay, so any improvement the licensor makes on the invention, I will want it to be transferred, even if it is in a later time that the license have been granted to. Okay, so you'll want all of this on your behalf. Technical patent knowledge, of course, it will be included or not. It will have the obligation of enforcement of the patent rights. I have talked about this already. It is crucial for this to be stated as an obligation of the licensor, because otherwise it will tend to confuse a judge or court regarding the nature of the license. It can turn the whole contract into an assignment if this enforcement clause is not included, or if it's transferred to the licensee. So, okay, this is important. Patent maintenance, of course, because if the licensor fails in its obligation of patent maintenance, then you will lose your licensee rights. Okay, this is logical. So this can be translated into damages. So you will want this as an obligation for the licensor. Some licenses obligations, of course, there are less, because the most responsibility on the license contract are charged over the licensors. But so licensee will have certain important obligations too, like royalty payments. Of course, that's the more important. It is crucial if you are the licensor that the licensee have to pay royalties, because this is what gives the license one of the most important aspects of the license agreement. So there won't be confusion about whether it really is a license or not. The exploitation, okay, so within the dismembered rights, which are the ones that the licenses have. I have already talked about this also. And non-compete is important because this will guarantee that the licensee will remain as interested party on your license obligation, will not put you in a damaging competing position with third parties. And here again, improvement, but as the other side of the coin, because you will want to establish what are the obligations of the licensee as per the improvements made upon the patent. Okay, so first you have to take into account if it is a patented active you have been transferring, if it is non-patented, and if it is patented, if it is a utility model, if it is an independent patent. All this you have to consider it before now talking about what will happen with the improvements, but from a licensee's standpoint. Okay, let me check on something here. Okay, so 2 slides and we're finished. And another important thing is the contract period. Okay, so we have a lot of stuff here. First thing is that, of course, you have an autonomy of will, which is there's no one name for it, the autonomy that parties have in order to, close the contract on the period they find not suitable. But you have to be very careful with the autonomy of will, because first of all, it may be damaging for you to grant a license for the whole period of the patent duration. Okay, so you wouldn't want that. Generally speaking, there may be cases you will want that, but generally speaking, you would not want that. So you have to be very precise on the matter. So which is why you have to be aware of the patent term. Okay, you cannot grant licenses that are bigger than the patent term. So technically, no patent license can be of more than 20 years unless you have a complementary certificate of protection, which is a figure that I don't know if it's applicable on your legal system, but it is a mechanism used in some legal system for increasing the life of a patent for approximately 5 years, okay, specifically for biotechnological patents. So if that's the case, then you can't grant a license for more than 20 years. If not, that's the cap there. You'll have to take into account public domain. It's very important, public domain. Because of course, if the patent gets into public domain, or certain part of the patent is in public domain, then of course that will end the contract immediately. This is mainly for knowledge transfer, knowledge provision agreements. Once the knowledge is known, of course, contract is ended right there. And you will have to also take into consideration if you are assigning or licensing the technology, because if you are assigning, contract will have a very short period of execution, which is, this contract will begin to be effective as per the signature of it, or that's it. But then it will have, the effects, indefinite effects, or will have the duration of the patent. If you're talking about a license, then you can cap that term. You can put limitations on the term. We'll also have to consider, if there is tacit renewal, which is important. You may want to include in the contract a clause that provides that there won't be tacit renewal. Okay, because if you don't include this clause, and for instance, the licensee pays you the royalty, and you don't say anything about it, and you just receive the royalty, and you knowingly, receive the royalty and don't tell anything to the licensee or give back the royalty, then you are tacitly assuming that the contract will be extended for the same period that it was initially signed. And so this can be dangerous for you in terms of exploitation. So you will want to include a clause establishing that no tacit renewal would be available for parties, and that any renewal of the contract will have to be previously negotiated and expressly right within the contract in the term of an amendment, and all that. That's the usual way of doing it, and it's the most safest way also. So free termination of the contract is also another thing you will have to include, depending on the side you're planning. And this can be expressly established in the contract, or can be implicitly included in the contract. It depends. Also, you will want to be aware of the effects of termination. Okay, termination of the contracts will have to be surviving provisions. For example, confidentiality is one of the most common surviving provisions. The cessation of use, if the patent is still alive, you will want to be very clear that there will be cessation of use if the contract ceases in effect. Okay, the remaining stocks, for instance, if the contract included manufacturing rights, what will happen to the remaining stocks? They can be sold, they have to be returned. You'll have to pay for these remaining stocks. All these, the return of assets like manuals, instructions, like laboratory bitacoras and stuff. So all of these have to be returned to the original owner. So these are some of the clauses or the sub-clauses that you have, sub-provisions that you have to establish within the termination provision of the contract. And of course, it will play a main role in contract period. And very important also, you will have to include in contract limitations, contractual limitations, for two main reasons. The main one is for you to be very clear that this is a license contract, otherwise it can be interpreted as an assignment, as I said before. And the second important reason is that you will, for practical effects, want to have the licensing limited as to the actions it can, develop around your IP. So the first one is exclusivity. It will be an exclusive contract or not. This may play an important role in the exclusivity clause, the exhaustion of rights. Okay, so you will have to be aware of which kind of exhaustion of rights is applicable to your country, international, regional, national, because this can play a role in exclusivity. Other thing you have to consider is the fact of no patent rights, use priority, and exposed licenses, ex-ante licenses. This may reference to I'm talking about exclusivity. You are not granting patenting rights to the licensee. Okay, so he doesn't, or she doesn't, or the company you are licensing the technology doesn't have use priority on the patent that belongs exclusively to you as licensor. Okay, so you have to be very clear on that. I'm not granting you patent rights as use priority rights, like the negative rights of the patents. You cannot forbid third parties for anything. Only me can do that. Okay, only I can enforce my patent rights. So that's important. And exposed license, sorry, and ex-ante licenses makes reference to the fact that you may want to take into account if you have given licenses before this exclusive right, okay, because that can affect the exclusivity. Okay, so you cannot give exclusivity over a technology if you have already give licenses before this one, and you may not give exposed licenses if you already have granted an exclusive license. So you have to, have this very clear. I cannot have granted licenses before, and I cannot grant licenses after this one. It depends on what kind of exclusivity you granted on territory, etc. But you have to consider it nevertheless. So territory and time, of course, territory is very interrelated with exclusivity, because exclusivity most of the times will be limited by territory. But also time is a very important limitation. I already explained it. You wouldn't want to give away license rights on indefinite time. We want to make a very specific cap of time there. You'll also will want to avoid most favored licensee. Okay, this is a clause pursued by licensees, but not so much by licensors, because it gives some rights that that like price preferences and cost preferences, and some rights of certain surveillance on your operations. You don't want to grant that kind of license rights. Sometimes you are forced to it for the situation or the negotiation, but you will want to avoid that. And also important, the sub-license faculties or prerogatives for the licensing. You will want to avoid that too, because sub-license open a whole world of new limitations and prohibitions in the frame of the contract. It makes the contract, the license contract, a lot more complicated if you give sub-license faculties to the licensee. It also diminishes the effect of limitations established upon it, and it may arise some confusion as to the nature of the contract, because, as I said many times before, this is a more common prerogative of assignments than it is of licenses. So, you know, in this matter, you have to be very careful. So I think that will be all in general terms. I hope that I have made myself clear on the matter, mainly because I understand you have quiz on this. I genuinely want you to, you know, get good grades on the quiz. I don't know if there are any questions. I believe this is a space for it. So if there is any doubt or question, I think I will receive it right now. Also, I apologize in advance if with the pronunciation of your names, but I will do my best. Okay, so Norayati, did I pronounce that well? Norayati? How are you? Of course, you can make your questions if you have, okay, explain more. Of course, okay, so you have the possibility, yeah, so Norayati is asking to make, explain a little more on the difference between IP assignment and IP sale, of course. So for instance, you may own an IP, okay, and you can commercialize from first hand this IP. So for instance, you may own a patent on a certain mechanism, and you may commercialize or sell this patent to a third party. Okay, and you are making a sale on this patent to a third one, owning the rights to it, and you are not giving away any kind of rights on this IP, yet you are exercising an exclusive right of intellectual property there, because only you can make such commercialization without licensing and without assigning the technology. Okay. On the other hand, when you're talking about assignment, you are giving away that IP for the third one, to make the commercialization of the technology. So the main difference is that IP sale is something that you can make on your own without licensing or without assignment, and but assignment is, you know, a renounce you make of the exclusive rights you have over the technology for the commercialization of it. I don't know if I made myself clear, and Norayati, if you need a little more explanation on that, let me know in the comments, please. Who is responsible for patent maintenance? This is from Cia Frisal. Who is responsible for patent maintenance? If either one transfer fails to pay maintenance with the owner of the patent, or the patent becomes free to operate. Okay, so this is a freedom you have as part of the contract. Okay, so if you're talking about a license, there's a presumption here that the owner of the patent, the current owner of the patent, will be mandated to you know, pay for the maintenance and the yearly maintenance of the patent. So the owner of it, okay. If you are gonna state it otherwise, you have to put it on the contract, because it is understood that if you are the owner, you have to take care of the maintenance of the patent. So the transferor, if you're talking about a license, the licensor will be responsible for maintaining the patent unless it is stated otherwise on the contract. Okay. If you're talking about an assignment, then the assignee will be responsible for maintenance of the patent. So it depends on which kind of contract you're using. The responsibility for maintaining the patent will be transferred or not. If I understand it right, IP assignment means we transfer the rights on the IP to a party. Yes, IP sales mean we also, yeah, you're right, Norayati. This means that in the IP sales, you can commercialize by yourself on first hand the IP without transferring any kind of right, okay? But there may be a tech transfer because, for instance, if you are selling a patent, you may transfer knowledge with it. You may transfer some IP with it without the possibility for the third party of exploiting the patent on its own without your authorization, without the possibility of the third party to manufacture the patent, without your authorization. So it can be understood as some kind of IP transfer. My pleasure. And I don't know if the maintenance question, the answer to the maintenance question of the patent was clear or not. Let me know as well. For trade secret, what's the best method of IP transfer should be considered? Okay, so in the cases of trade secret, I would say that the best method is sale. Trade secret is based on a premise that the information is secret. Of course, this may sound obvious, but it is not as much when we're talking about transferring, because we, tend to talk a lot about transferring the secret, and it is not the best way for exploitation. If you are exploiting a trade secret, the best way to do it is not transferring it at all and exploiting it yourself, because that will be the safest way, since trade secret needs to remain secret. Okay, so, but if you are, willing to exploit the trade secret, not by yourself, but using a third party or an associate in this case, I believe that the best way to do it so is, to directly assign the secret, get rid of it, make evaluation how much the secret may cost if transferred, give away the secret in its wholeness, and let the third party exploit it. Yeah, outright sale. Yeah, definitely. Because, you have to, in the case of a license, which it is technically inappropriate to call it a license, I explained that already. But in the case of a license, if you want to call it that way, you have to bear the burden of keep the secret for yourself and make the work of this third party also. And you have to have, you will have to have a very complicated secret protocol in place to keep this working. So the way companies work around trade secret generally is they just give away a part of the secret. They do not give away the whole secret. And they keep the main secret of the main core of the secret with them and just give a part of it. Or they use, I don't know if you have this mechanism on your country, but they use something called a certification trademark, which is a trademark that is not used by the owner, but by third parties. And they use the secret and they exploit the secret that way as a form of complement for the secret exploitation. Okay, so yeah, outright sale. I think there will be outright sale or exploiting it yourself. Like, for instance, if the secret is about a procedure for the production of some technology, then the best way is for yourself to keep the secret and exploiting it yourself. Like, I will myself manufacture the product and then sell it to other parties, the third one, commercialize it, whatever. But I won't transfer the secret for other to know how to, not under license, not under the outright sale or anything. Okay, so no, thank you for the question. It was a very good question. And it is a frequently asked question on these matters. I don't know if there's anyone else. Okay, if there are not more questions, then to finalize the presentation, I would very much like to thank you for the attendance and for the attention. I hope this will have proved to be useful for you, for your, daily practice in your offices and in your work. And I will remain at your disposal through email, or you can contact me by any means you want to solve any additional questions you have on the presentation or in any practical matters that arise for you. And once again, thanking you for the opportunity of being here today talking to you. So I wish you a nice day and a nice rest of event.
Thank you so much, Mr. Marino, for your presentation. It was most useful and helpful. I hope that the participants can make the most of it. We will take now a 10 minutes break, and when we will start with our next presentation. Thank you so much for attending. Thank you.
Thank you.
Hello, Dr. Brian Khan, can you hear me?
Yes, I can hear you. Good afternoon.
Good afternoon to you too, sir. I would like to welcome you to our meeting and thank you for attending today.
Thank you. It's my pleasure to be here. So should I share my slides and begin?
Let me just give a few words of introduction first, and then you can.
Thank you.
So joining us today is Dr. Brian Khan, who will be talking about a patent. What is a patent? The macro and microeconomic impact of the patent system. Dr. Khan has a PhD in law and economics from Hamburg University, with more than 15 years of experience in the field of intellectual property. He's the vice president of the Joint Master's Program in Intellectual Property Law at the University of Turin and the Academy of the World Intellectual Property Organization and consultant on projects related to international trade law, international property, and economic policy. Advisor and lecturer at West Indies University, Harvard Law School, and University of Turin, Italy. Welcome to you, Dr. Khan, and you may start your topic now.
Great. I hope you all see my slides. So good afternoon. Assalamu alaikum. I'm Dr. Khan Brian. I'm joining you from Trinidad and Tobago. And those who don't know, that's a small island in the Southern Caribbean. And my background is a bit different from most people, talking on this topic, in that I am not a lawyer, or I'm not from the field of science and technology directly. I'm an economist, so I'll be speaking about things from a slightly different angle. And I got the last maybe 10 minutes of the last session, and I know you had a wonderful introduction to intellectual property and patent law. And so what we're going to do now is take a sort of big step back. Instead of talking about the nuts and bolts of how the patent machinery works, we're going to talk about sort of the high-level concepts and how the patent system plays a role in the economic functioning of society in general. So just to start with some very, broad philosophical comments, one may ask, why do we need to look at the economic side of things? You know, economists tend to be very theoretical, very abstract, while the world of patents and research tends to be very concrete and very practical. And to me, the goal here is to see the big picture, because to really understand patent law, it's not just understanding law, it's legislation, regulations, it's understanding the dynamics of research, the dynamics of innovation, and then also understanding the economic context of innovation and what that means for businesses, what that means for governments, what that means for the economy as a whole. So it really requires a multidisciplinary approach to understand the patent system. So we're going to take a big step back here to see the big picture and contextualize what you'll be learning over the next 3 days about the patent system, contextualize it in terms of the significance of patents for a national economy, for a country, and for the commercial context in which all of you might operate. The second kind of broad point to me, specifically for this audience, is that when I think of the regions we're concerned with here, when I think of the pan-Arab world, when I think of Persia, the Muslim world, I think of a region that has historically had such an important role in the development of mathematics, of science and medicine throughout human history. It's a very, very rich and deeply embedded tradition of innovation, you know, that made unmeasurable contributions to the development of mankind. So how do we take that history and look at your countries and adapt that to what it means to operate today, where it's a very different world of innovation, contextualized by all these international laws and all these trade agreements, which sort of regulate how innovation and technology develop in very different ways. So those are just very kind of philosophical statements to start off. So before kind of getting into the content, I think it's good to just be clear of what we're talking about. The title of the presentation was the macroeconomic and microeconomic impacts of the patent system. So maybe we should begin with what those terms mean. So microeconomics is a study of individual economic agents. We're talking about individual consumers, households, individual firms. And then all of these agents come together to form markets, meaning supply and demand. Consumers demand things and companies supply them. When we put all those agents together and we aggregate them and study the nation's economy as a whole, we have what you call macroeconomics. So the focus in macroeconomics would be aggregate consumers and firms, all these markets together. So micro means we're talking about individual markets. Macro means we're talking more about the interests of the policymaker, of the government in managing the national economy as a whole. And then I would say, going beyond these very kind of textbook definitions, what we're more concerned with is what I would call beyond the macro view. First of all, international trade. How do the macroeconomies of different companies, different countries interact with each other? What is the relationship between nations as it relates to innovation and technology? And then second, the question of economic development. That is a question of how to grow an economy and improve the living conditions for the citizens living in that country. So these are the different sort of perspectives we'll be looking at today. So microeconomic view, then a macroeconomic view, and going beyond that macro view to international trade and economic development. So beginning with the micro, and again, I apologize if everything sounds very theoretical, but this is the nature of economics, and trust me that the pieces will start to fit together and make sense. The fundamental question for an economy is the question of economic organization. A country must decide, how does it provide for the material needs of its people? And throughout history, there's sort of two competing aspects here in that question of economic organization: the role of the state or the government, of the role of markets. So you have on one hand planned economies where the government sort of steps in and plans every detail of economic life. And then you have on the other hand market economies where we let these free market forces of supply and demand determine the material conditions under which people live. And the truth is most countries are somewhere in between. No country is a pure market economy or planned economy. So in modern times, in modern ideology, in this globalized world we live in, the view is that free markets are generally the most efficient mechanism to provide these material needs of society and allocate scarce resources. We have a view that when the market can accomplish a task, there's no need for the state or government to accomplish that task. And that the whole international economic system has been built around this view that free markets are the most efficient means of economic and social organization. So that means that the focus should be on promoting competition. And promoting competition means preventing monopoly power. So that being said, when we talk about the microeconomic rationale for the patent system, throughout the history of the patent system, looking back hundreds of years, we have sort of 4 theories or 4 viewpoints which have driven the thought of how patent policy should be developed. So we'll start first with the sort of dominant one, the most important one in modern time really, which is this idea of incentive inducement. What is this theory about? It suggests that we need patents to incentivize innovative activity, because without the state intervening by given patent rights, the free market system will not produce interventions, right? In economic terms, we call this a market failure. I know there's a lot of jargon, but I'll explain what these terms mean. So information is what we call a public good. It's non-rival and non-excludable. When we talk about public goods, it doesn't mean something provided for the public. It's a technical economic term. And the sort of textbook example of a public good is a street light. If you install a street light, one house will enjoy a lit road, but you can't stop the house across the street from also enjoying that light. There's no way to exclude someone from enjoying street lights. And there's no way that if one person uses a street light, it diminishes the capacity of someone else to do so. And the idea is, as such, you can't charge people for street lights. A free market will not provide street lights, so the government steps in and installs street lights at the side of major roads. So information, like a scientific or technical idea, once it's created, the creator cannot prevent others from using that information. And if this is the case, then in theory at least, private actors, private companies, private researchers and inventors might have no incentive to produce something because they spend a lot of time and money inventing something, and then others come along and benefit from that thing without a restriction. Or in other words, they free ride off of it. So we say that the market fails, or if we just left the market alone, it won't be sufficient to produce the innovations that society needs. So what do? The government needs to intervene in some way. So what kind of interventions can we make? Well, the state can provide the good, like the example with the street lights, or the state can subsidize the good, meaning we give some incentive, some money, some subsidies to private companies to provide this thing that society needs. Or we can make this good excludable, making sure that you have some capacity to exclude people who did not pay from using this thing. And what this means for inventions and technical ideas specifically is that state provision of the good amounts to public sector research. If the market isn't going to provide innovations, well, the government can set up research centers, research institutes, and conduct public sector research. Similarly, it can give research grants to private institutions, to private universities, and support research and innovation in that way by subsidizing production of the good. Or the third option, to make the good excludable, make information excludable, we can give intellectual property rights. In this case, a patent right. And by making it excludable, we return that process of creating innovations to the free market. We say the market should figure itself out now that you have a property right, and the free market should be able to provide innovations now. And of course, these things aren't mutually exclusive. They're all different tools that we use throughout the innovative ecosystem. So a policymaker does not choose patent rights or research grants or public sector research. It's a combination of all these things depending on national priorities and the policy choices of those managing the economy. So we have a trade-off now. We have two kind of competing views. On one hand, economic efficiency means free markets and no monopolies. But now on the other hand, we're saying we need IP rights. And IP rights are effectively short-term monopolies on technical information. So these things seem to be at odds with each other. And we reconcile that difference by saying, well, as a society, we are willing to accept the short-term harms of a monopoly in return for the long-term benefits of innovation, right? IP rights are by design aren't perfect. They're imperfect because they create monopolies, but we're willing to accept that imperfection, that harm, in return for long-term innovation. So the short-term harm of monopoly is the way it undermines efficient competition. And the long-term benefits are that innovation allows for greater scope of economic activity, new goods and services, new solutions to the problems that humans face. So this is the inherent microeconomic trade-off. And this is what we need to keep in mind, that when we're talking about the patent system, there are costs to society and benefits to society. So the goal is to sort of balance things. We want to calibrate intellectual property rights. We want to create a system to optimize this trade-off between innovation on one hand and competition on the other. So if we give too strong incentives, we create unnecessary market power, right? We undermine competition. But if we give too weak incentives, we don't do enough to stimulate innovation. We undermine innovation. So we need to design a patent system which just achieves that perfect little balance. In more developed jurisdictions, particularly in North America and Western Europe, here we have a strong role for antitrust law, competition law, to step in where rights are too strong and distort competition. But that is not, at this point in history, as big a factor in the global South or the global East. It's more of a Western sort of concept of the government's role in managing the economy. But I would say that, you know, it's a matter of time before the idea of antitrust law and competition law spreads more throughout the world and countries all over strengthen their antitrust law. The point here being, in this balance between competition and innovation, yes, we're talking about intellectual property, but we have this role for this other body of law we call antitrust or competition law. So for every patent, there's a balance between two things, right? The social harm of the patent in restricting competition, and then the social benefits of the patent in creating knowledge. So it's important to only protect the innovations where this social benefit is greater than the social harm. We never want to give a patent which ends up harming society. What does this mean? I'm talking about theoretical abstract things. What does this actually mean for the patent system? Well, it means this idea of only giving patents for things that are socially beneficial manifests in the substantive patentable criteria. Novelty, then non-obviousness or inventive step, and thirdly, utility or industrial application. So if invention is able to meet these three criteria, it can be granted a patent. So the idea is we want patents only over novel things. If something is not new, we don't give a patent, because giving a patent to something which is not new does not benefit society in any way. It only harms it. If a solution to a technical problem is obvious or it does not involve an inventive step, then to give a patent would be socially harmful, because we didn't need that incentive of this monopoly power, right? Someone would have just figured the solution out because it's obvious without that incentive. And in terms of utility or industrial application, there's no point in giving a patent over something which can't be implemented or has no actual capacity to be produced. So we don't give patents over things like an idea for a time machine or perpetual motion machine, because the laws of physics say you can't have those things. And therefore, there's no point in giving a patent over those things because they can't actually be produced. There's no social benefit in giving such a patent. So in these legal concepts of novelty, non-obviousness, and utility, you should always remember that the purpose that we have these criteria is to ensure that when we give a patent, that patent is over something which generates social benefits, and social benefits which are great enough to be more than the social harm caused by the monopoly power. So we want to give an IP right which is just enough to incentivize innovation. We don't want to give too strong an IP right because monopolies are harmful, right? So the problem is every sector and field of science is different. In different sectors of research, you have different rules of how research happens throughout this innovation train, or the rules of primary research, the rules of the state and public sector research, and the rules of the private sector. In every form of production, the costs of research and development are different. The capital costs you invest in labs and equipment and staff are different. Every product has a different scope for reverse engineering. There's a big difference between something like a process, which happens behind the scenes in a factory, which can be patented, and a product, which a consumer or competitor can see and sort of figure out the technology in it by a process of reverse engineering. And in every market, there's a different first to market advantage, even without a patent. If you invent something and you're the first company to commercialize it, you have an advantage. Even if the competitors can copy and come afterwards, you had an advantage by being first to the market and developing your consumer base first. So an example here is like a manufacturing process versus like chemicals or pharmaceuticals. Manufacturing processes, again, are things that happen behind the scenes, hard to reverse engineer, easy to keep secret. They need a very different incentive than something like a chemical invention, pharmaceutical invention, because pharmaceuticals take millions of dollars to be developed. But then once it's developed, it's just a matter of sending a pill to a laboratory and your competitor can figure out the chemical composition of that pill. So the point is these two sectors need very different incentives, right? They need very different kind of economic interventions to promote these types of innovations. So then why do we have a patent system where one size fits all? The patent for a manufacturing process is generally the same as a patent for a pharmaceutical. This seems at odds with the idea that every sector is different in terms of the incentive it needs. So I would suggest that yes, an economist would say that the incentives are different across sectors, so maybe patents should be different, but it's not practical. There are justifications for having a patent that's kind of one size fits all or treats all forms of technology equally. For example, overregulation by the state can actually distort investment patents. If we start to set patent law, there's one patent law for manufacturing and then one for telecommunications and one for pharmaceuticals. It can really mess up investment patterns and distort the free market. And the idea is, again, we want to intervene just enough for the free market to operate effectively. So over-regulating or passing too detailed laws which are imperfect themselves can distort those free market processes. Secondly, patent law is not everything. Many fields have non-IP regulatory requirements. So in pharmaceuticals or chemicals, sure, you can invent something and get a patent, but we have a whole body of regulatory law which says what you can do with an agricultural chemical. It needs to be tested. It needs to be proven that it's not harmful to humans, to the environment. The same with the very complex process of clinical trials for pharmaceuticals. Those are all non-regulatory requirements aside from the patent system. So even if the patent system is one size fits all for technology, there are other bodies of law which are relevant to different sectors. Thirdly, as we said, patent law isn't everything. Sure, the patent is the same for all forms of technology, but there are other policy tools to guide innovation. Education. Some countries decide to focus their education systems on STEM, science, technology, engineering, and math, because they want to guide education and students and the new generation of workers into a certain direction and into certain industries. Or subsidies. One size might fit all for patents, but the government can still choose which sectors it wants to subsidize to promote that type of technology. So many Western countries now are subsidizing things like green technology and research into inventions to mitigate the effects of climate change. And then simply, it's impossible to predict new technological fields. So if we made this different patent system for all kinds of technologies, we can't think of all the technologies that will ever exist in the future. So many decades ago, we couldn't conceive of something like artificial intelligence or 3D printing. And if those things weren't accommodated for by a patent system, which is meant to suit all forms of technology, maybe those forms of technology would have never developed, because we can't predict all the fields of technology that might come in the future. So this is just a kind of justification of why we have a patent system which treats all technology the same, even though this idea of economic incentivization suggests that incentives are different for sectors. And then another very important thing, simply put, the TRIPS agreement, which is the most important international trade agreement regarding intellectual property administered by the World Trade Organization, it says that countries cannot discriminate between the field of technology when it comes to patents. So even if we wanted different patents, let's say a 20-year patent for pharmaceutical, but a 25-year patent for agriculture, it would not be permitted under trade law. So discrimination by subject matter is simply not allowed under international trade law. So that was about incentive inducement, this idea that patents are needed to incentivize innovation, because without state intervention, we would not have inventions. And then we talked a bit about, well, how these incentives differ across different fields, but why the patent system is the way it is, in that it's just one thing rather than several other sector-specific bodies of law. The second view we look at is disclosure theory, or the disclosure view. And here the idea is that patents are needed to incentivize the disclosure of interventions that would be created. We don't need incentives for these things to be created. They'll be created no matter what. But when they're created, people will keep them secret. And we don't want people to keep them secret. We want them to disclose their inventions. So from an economic point of view, we want to incentivize disclosure. So the microeconomic choice of a company is to choose a patent or a trade secret. I know you're talking a bit about this before in the earlier session, but okay, so a patent can be maximum 20 years. That's not very long at all in the context of a business. But a trade secret can be perpetual, you know? Coca-Cola has had its secret recipe secret for more than 100 years. Patents involve disclosure of technology. We let society know the thing we invented, while trade secret is the opposite. Knowledge is kept secret. Patents, you have a very strong monopoly. No one can do a wide range of acts without your permission. But then with a trade secret, once someone reverse engineers your secret, once someone figures it out, then there's nothing you can do. Reverse engineering is allowed. And then a very patent intensive strategy tends to be very costly for the firm in terms of how it manages its processes of not disclosing by mistake, of hiring patent lawyers, of doing all these things to orient its business strategy around a patent portfolio. Trade secrets are less costly, or at least directly costly. Of course, there's still costs involved in making sure that you have contracts with the employees that say you can't disclose this secret and all of that. But patents are generally have more direct costs. So what is the point of microeconomic perspective here? Well, society, the economy, prefers the social contract of a patent to a trade secret. And by the social contract, what we mean is that society is saying, I give you a patent, which is a monopoly right. And in return, you disclose your technical information. You take this knowledge you've created and put it into the pool of global knowledge that society can use. And the goal of the patent system is therefore to pull innovations over from trade secrets. We want to encourage people, hey, instead of keeping this thing a secret, we want you to patent it so that your information can enter this global commons, this pool of knowledge that society can then benefit from, that can further more science, more technology, and more research. So it sounds abstract and it sounds like just a general principle to guide policy making, but you'll be surprised to know that the patent system is sort of designed to do this. And we can see that in the way patent terms and fees are constructed. So first of all, in terms of patent terms, we talk about a patent like it lasts 20 years. It doesn't. It lasts a maximum of 20 years, but you need to always renew it. In truth, statistically, the average effective life of a patent tends to be about 5 years. The majority of patents end up being abandoned after 5 years, meaning that the inventor does not renew the patent by paying the fees to the IP office. Less than 40% of patents are maintained until the end of their term. So less than 40% of patents are actually go to the last 20 years. The vast majority are abandoned quite quickly. And this might be surprising, but society actually wants to encourage the abandonment of patents. Remember, I'm not talking about a business. I'm talking about the economy and what's in the best interest of the macro economy. So why would society want to encourage abandonment of patents if we design this whole system to grant patents? Well, once a patent is granted, we've already benefited from innovation, meaning the new goods and services on the market. Society has already enjoyed the benefits of disclosure, meaning the applicant has already added their technical knowledge and increased the stock of technical knowledge by disclosing the invention in their patent application. So we've gotten the benefits from a social point of view. Now we're dealing with the social costs of monopoly that the patent has created. And we want to minimize those costs to society of monopoly. We've already gotten the benefits. Now we want to minimize the costs of monopoly. So if you look at patent fees, you'll see something very, very interesting. So on your screen are the patent fees of what we call the IP5, the world's 5 biggest IP offices. The European Patent Office, the US Patent Office, and that of Japan, China, and South Korea. Those 5 IP offices represent the vast majority of patent applications all over the world. And again, remember, once you're granted a patent, each year you're expected to pay some renewal fee. So you'll see that every year the fees are going up and up and up. On the 10th year, it's much more expensive to maintain your patent than the first year, right? And remember, we already said that after year 5, the vast majority of inventors abandon their patent. What is the point of this? Again, from this economic idea of social costs and social benefit, we want to minimize the social cost of monopoly, or we want to ensure that only the most commercially viable patents remain unenforceable. if the patent is not worth it and not doing anything for business or not doing anything for society because it's not being used or it's not generating income or it's not commercially viable to remain valid, then you want to have a mechanism to kind of push the inventor in a way of saying, hey, just abandon your patent. And that is by design. That is, we see that in these increasing patent fees. And I would also observe that this is not just something that big Western countries do. These big industrialized countries like Western Europe and the US, we see this all over the world. And in the region we're concerned with, we see the same thing. This is just some information on patent renewal fees from the WIPO PCT database for some of the countries where we're talking about over this week. Pakistan, Egypt, Iran, Lebanon, Jordan, Saudi Arabia, all these countries do have increasing patent fees over the years. So the point is here, we have increasing patent fees under this disclosure perspective because we want to make sure that only the most commercially viable patents remain enforceable. And this is something almost universally done by design by all patent offices all over the world. So that was disclosure theory, talking about the idea that the patent system is meant to pull things over from trade secrets into patents. And we talked about how disclosure relates to the idea of increasing patent fees. The third theory or the third view is that the idea of development and commercialization. Patents are needed to create an asset base for inventions, to attract the funding they need for commercialization. So again, this is a bit different. We're not saying things wouldn't be invented without patents. We're thinking things wouldn't be commercialized. Researchers will always research. Scientists will always research. Inventors will invent. But we need to make sure that those inventions actually result in the production of new goods and services. Otherwise, there's no value to the macroeconomy. So the general concept is that researchers and innovators have these very specialized technical skills, but not necessarily entrepreneurial capacity to commercialize their inventions. So patents create a property right, and by creating a property right, they create a means that can be used as a basis to attract capital funding, a basis that can be transferred or licensed to someone else that has entrepreneurial or productive capacity. So this is very important because kind of historically, the idea was that you have a company that does everything. You invent something, then you take that invention to a factory, you're able to produce that thing, then you're able to market it and actually sell it to consumers. But by having a patent that can be licensed, we're saying we don't just need these big vertically integrated companies. We're creating an important role in the economy for SMEs, small and medium enterprises. So this is really important. This is how patents help SMEs and not just big global corporations, because it means that vertical integration is not necessary to succeed, but sort of horizontal diversity is possible. My small company can specialize in innovation. Once I have my patent, I can pass the next task of actually producing the good to someone else through licensing. And they can pass that to someone else to actually sell that has entrepreneurial activity. And this way, we create a means for innovation to be commercialized even if a company doesn't have productive capacity, or allow that company to grow. A small company can now grow and develop this productive capacity over time. And so again, the idea here is that the small and medium business can benefit, which is very important for the economy, especially in developing countries. Other important dimensions on this kind of logic, just kind of a few minor things. First is Bayh-Dole type legislation. So the Bayh-Dole was a 1980 piece of legislation in the United States, which suggested that when a university invents something using public funds, the university is allowed to patent it and commercialize that invention. That's very important, because if we just let the state or the government have a patent, as the government has no incentive, no capacity, they just have these patents lying around and these things are never commercialized. So there's special types of legislation about ownership rules for research, which results in inventions using public funds. This type of legislation is important because it creates a means for publicly funded research to be commercialized. Another important thing for our countries, which we need to talk about more, is capacity in IP valuation and collateralization. We're not going to attract the capital we need to have our patents commercialized if there's no mechanism in the market to value this patent. We need experts to sit down and say, okay, this patent is worth this much on the open market. It's worth this much in royalties. And then collateralization, the capacity to go to a bank and use an intellectual property right as collateral to get a loan, a small business loan, just as you would with a piece of land or a home or any other form of property. And then the last point here, we're seeing an important role for IP management. So IP management is really something interdisciplinary. And it's really only in the last maybe 20 years we're paying more attention to the fact that IP management means we don't want these processes run just by lawyers or just by researchers or just by business people, but people who have all these skills together. So for you as someone operating in research or the business side, you need to have all these different perspectives, the economic, the legal, the business, the technical, in order to engage in this process of IP management and understanding how the patent relates to these actual business processes. And at the level of research institutions or universities, this is what we call a TTO, or Technology Transfer Office. So the point here was just talking about the role of patents in linking inventors and industry together. And these are just some of the dimensions of that concept. So besides all of that, patents still have this other role in what an economist might call signaling. So even if a specific patent doesn't have commercial potential, it still has value. It functions to signal something to the market. What does this mean? A lot of inventions are interesting. A lot of research we produce is academically important, scientifically important, but it doesn't necessarily result in something which can be commercialized and make profit. But it still has a function because that patent communicates something to the market. What does it communicate? It communicates that your firm, your business, your research institute is active in a certain field of research and might be a desirable business partner. So just because your specific patent mightn't have commercial potential, it shows that your firm as a whole has commercial potential because there's the expectation that you'll do more research and eventually you would become profitable. It communicates that the firm might be on the path to producing more commercially viable follow-on inventions, which need to be funded. So investors look at this. Investors look all over the market at research institutes and small companies and see what they're patenting. And what you patent might not in itself have commercial potential, but you might identify it as something which might have many follow-on inventions. It might be the starting point for other inventions and other patents, which themselves would be commercial viable. So an investor would say, you know what? I want to get in early on this business and give them capital funding now, because even though this current patent is not profitable, I expect that this current patent will lead to follow-on patents which are profitable. Again, all of this is the idea of the patent communicating certain information to the market. And lastly, on the individual level, we have a very interesting thing about an individual researcher. A patent shows that an individual has a history of successful research output, even if you're not motivated by profit. So if you're working in a university, your success as a professor is about how much you publish. If you're working in engineering, your success can be measured by how many patents you have your name on. So if you're an inventor, if you're an engineer, your CV might list the patents you have. And then this is how we get this weird term called wall patents. Patents which people apply for and have granted, and they just put it on the wall to look nice. And they're never commercialized. But those still have value because it's signaling the capacity of an individual to do successful research. That helps you with your career in the academic world. It helps you get tenure. It helps you be sort of hunted by other companies for jobs. Trust that big technological companies are looking all over the world at patent applications, not just to see which companies are patenting what, but which researchers and inventors are producing what. So maybe a big company like Google or Amazon might see your name on a patent and said, this is someone I want to hire, and then contact you and say, yes, I want you to come to my company. So again, the idea of signaling is that the patent is communicating this very valuable information and therefore has this role beyond just commercialization alone. So that was a bit of what we might call development and commercialization theory. We talked about how patents are used to attract funding, to make small businesses grow into big businesses, to encourage horizontal relationships rather than vertical integration, and this idea of signaling. The last and perhaps least interesting view on the patent system from a microeconomic perspective is prospect development theory. But we'll try to make it interesting nevertheless. And the idea of prospect development is that patents are needed to encourage the orderly development of technology. And it does this by sort of demarking research territory. So a prospector, on the picture on the screen here, a kind of cliche picture of an American prospector. These guys who went out to the western expansions of America and Canada looking for gold. So the government would cut up land and say, you can look for gold in this parcel of land, someone else can look for gold in this other parcel. We don't want you overlapping because that's wasteful. There's no point in two people digging up the same land. It's just repetitive and a waste of resources. In our part of the world, the better analogy might be the oil industry. The government invests in searching and exploring the seas and land for oil and natural gas, but it does this in a very orderly way. So we cut up the area where we think oil might be, and we said we give a license to company A to look in this area and drill here, and we want company B to look in this other area. We don't want them to overlap because overlap is wasteful. If two people are doing the same thing and investing millions of dollars in the same thing, it's possibly wasteful. So the idea here is the patent system does something like this. It cuts up research territory. So if I patent a certain very specific field of technology, it's therefore the market identifying that my company is operating in that territory. No one else needs to jump in and look at that particular technical issue. You should focus your attention on other technical issues because my company has already solved that problem. I mean, this was kind of popular in the 1970s. It's not really strongly held view today because the truth is we know we compete. Many companies spend money researching the same thing because the first one to figure it out gets the patent benefits. So we do have a lot of overlap in R&D, people researching the same thing, which is kind of contrary to what a scientist wants to do by sharing information and avoiding duplication of research. So in terms of what prospect theory might mean for today, to me, we should look at the role of what we call patent information. So we should think of these databases of patent documents as a public resource, as an economic resource. So eSpaceNet, which is the, yes, Abu Bakr. So I think we're gonna go until 40 minutes past, and then we're gonna have a 20 minutes Q&A. So just feel free to put your question in the chat or maybe just take a note of it and then we'll return to it. I hope that's not a problem for you. I'm just responding to the raised hand. that I see. So yes, eSpaceNet, which is the patent database of the European Patent Office, has over 130 million published documents. That's an really like unfathomable amount of information. Like I can't picture what 130 million documents looks like. And it's estimated that about 2/3 of this technical information has not been published elsewhere. A lot of time, yes, information is published in a scientific journal, in other sources, in business documents, in plans, but a lot of it is only in these patent documents. So these patent documents, these databases, therefore represent a repository of information that is technical information that is nowhere else to be found. So economies lose billions of dollars every year from not using patent information. We duplicate research. You know, governments might fund a project, not realizing that somewhere else in the world, someone else funded a similar project and already found a technical solution to this problem. And we're just duplicating research costs and wasting information. Similarly, companies waste valuable resources by not doing what we call a freedom to operate search. When you're starting a new business, you need to search a patent landscape to make sure that your actions aren't infringing on someone else's patents, or that you are able to carry out your business plan unencumbered by a third party's intellectual property rights. So very often, investors, entrepreneurs, inventors start up a company, a small company, and they go through all the entrepreneurial processes to bring this company to market. And when it's time to launch, you realize you get a cease and desist letter from some other pre-existing company claiming you're infringing on their patent because you did not do this freedom to operate search. You did not search the existing patent database to see if what you're doing is permissible. So all those entrepreneurial efforts and investments in the company end up being wasted. So I'm just relating to this idea of prospecting and how the patent system has a role in orderly development of technology, in that it's kind of manages this process of avoiding duplication and wasting of resources, if it is that we use these patent databases as we should, both from a public and private perspective. I just have a few more slides, and maybe I could break and take the question of the hand up. In many dynamic sectors in very complex fields of technology, the patent landscape is just this big overlap of firms, and each firm has this big patent portfolio, and they're all interrelated. Like in your cell phone, there are thousands of patents related to the technology in your cell phone. Right? So here's an example of what we call a patent thicket in the telecoms industry. It's not very clear, I apologize for that. But each of these names here is a company, a telecommunications company. So we have the biggest companies like Sony, Motorola, Qualcomm, Nokia. And each one of these gray lines represents a licensing agreement between them in terms of technology. So the telecoms industry is just this massive network of very, very complicated licensing agreements, thousands of these licensing agreements. If you're a new company trying to enter into the telecommunications industry, it is massively difficult to even navigate and understand this space. Who owns what? And how do we manage all these rights? So the idea of patents allowing for orderly development works in many ways in these complicated situations. So the first one is what we call a patent pool. So a patent pool is where companies say, okay, I own many patents, you own many patents, we need each other's patents. Let's just put them all into a common pool. And anyone operating into this industry can go into that pool and use that, right? Rather than us having to individually negotiate each of these thousands of licenses, which just do not really make sense from a business management perspective. Something like that is only possible with a property right of a patent. If we all kept our technology secret, such a kind of pooling mechanism would not be possible. And such a complex thing like the telecommunications industry would not be possible. We also gives companies negotiation collateral. You know, when Google wants to do a deal with Apple, they both have something to negotiate with each other because they both want to use each other's patents. So owning these patents allow for these companies to have a basis to collaborate. And then the third one, to put the third point there, is defensive patenting. The idea that sometimes we patent things we might otherwise patent because we know the other companies need to use them. And then we set up what we might call the risk of mutual destruction. If one of these companies decides to sue the other, and then the other decides to sue them back, and everyone decides to sue each other, we have thousands of lawsuits and the whole industry falls apart. So having a patent is almost like a defensive mechanism. In case someone else threatens to sue me for using their thing, I can threaten to sue them for using my thing. So all of these are just examples of how in a very complicated network industry like telecommunications, the patent system allows for orderly development of this sector. Then we have this special case of standard essential patents. This might relate to Abu Bakar's question, which I'll get to in a minute. And the idea of a standard essential patent is, well, sometimes we have things which are standards. They're protocols that everyone needs to use. So if you have a patent over 3D technology, development of 4G technology relies on that. And then development of 5G technology relies on 4G technology. And if you own the patent related to 5G protocols, none of these 5G applications, whether they be internet, mobile, banking, the Internet of Things, smart cars, smart batteries, none of these things would be possible. So if you own a patent, which is a standard, meaning that the industry or regulator decides that it's a standard protocol and everyone needs to use it, we call it a standard essential patent. And we treat those differently. You can't have too strong a monopoly over that thing and hide it away from everyone else, because then no one can participate and this technology will never be developed. So we have a special case for standard essential patents. This kind of relates to the conversation before on antitrust law and special rules for these types of situations. So that kind of brings me to the end of this part of the talk, economic rationales for the patent system. And we talked about 4 perspectives: investment, inducive, disclosure, commercialization, development. And I highlighted these 4 words there, which kind of summarize everything. Patents are meant to incentivize innovation, disclose innovation, commercialize innovation, and develop innovation. So I'm just reading the question in the chat now from Abu Bakar. Is there any role the WTO plays in ensuring that overprotection of IPs in member countries do not lead to protectionism or monopoly in the marketplace, especially for essential goods? So I think this is where we allow in international law a role. There's no agreement on competition law, but we acknowledge a role of competition law to step in when something is essential. And I think that's like the example we're talking about a standard essential good. So a court could step in, a regulator could step in, or the legislator could step in and say, if you have an essential good, something like a standard which everyone else needs, is special rules for you, meaning you need to license your technology on certain fair and non-discriminatory terms in order to allow for technology to flourish, instead of having this protectionism that you refer to. So that's how that would operate on the competition or microeconomic level. In a bit, we'll talk about the macroeconomic level and what there is in the WTO rules regarding that. So I hope that answers your question. Yes, please, Abu Bakr, you can. It's okay. I see a raised hand. Okay, so maybe we'll get back to that at the end. So now we're going to turn to the macroeconomic side of things, which is looking at the bigger picture. We're stepping back from looking at markets and how individual businesses operate, and we're talking about if we're a government, if we're a policymaker, if we're a regulator, if we're the one in charge of the whole country, how do we look at the patent system and its role? So just some basic, kind of very obvious concepts there. Successful local companies are important to a country because they contribute to GDP, they contribute to job creation, they contribute to tax revenue, and they contribute to economic growth. So a government wants successful local companies, obviously, this is an obvious fact. And companies that innovate, meaning that they create and they supply new and improved products and new and improved services, tend to be more successful in this environment of competitive markets. So successful innovation, therefore, is something we want to encourage, and it requires an ecosystem of different actors across society, not just the patent system. So improving the patent system does very little if other aspects of this whole system are not optimized. So very often in developing countries, we have patent laws, we have an IP office, but innovation doesn't really function effectively because there's no mechanism for funding. We don't have financial markets to make sure that inventors are able to access capital to start businesses. So there are all these different things in what we call an innovation ecosystem, of which the patent system is just one small part. So just here's, won't go through this in detail, but this is just a kind of visualization of what the IDIA, which is an International Forum for Innovation, describes as the scaling pathway, how you go from a small idea to a big business. And you see there's so many agents involved there. At the very beginning, you have friends and family, you have who you talk over ideas with. It sounds minor, but social institutions are important for forming ideas and education and innovating. Then we have this in a more structured way in research institutions. We have civil society organizations which influence governments in which direction research should take. Then once we have research, we need to prove that these concepts actually work. We have incubators and accelerators. We have development agencies which all help the development of an idea into a business. We have professional services like investors, venture capitalists, and private equity firms, which all provide the capital needed for an invention to actually be taken to market, to actually start a business. All of them operate at different points in this innovation chain. And we have all these different sets of market facilitators and intermediaries, both in terms of private actors and government actors. So in going from a scientific idea to a successful business, there's so many people involved. There's so many different actors and so many different aspects involved. And if we want innovation to contribute to the macroeconomy, we have to be looking at all these different steps, all these different agents, and not just research and development and investment in science only. Taking a very sharp turn in the conversation here, I'd like to talk a bit about economic development and international trade. So a bit of a different conversation, but taking a step back here on two concepts. The first concept here is what we call an infant industry argument. The infant industry argument is that before my country can participate in international trade and compete with all these big companies all over the world, I need to protect my small businesses. I need to make sure that small businesses have the opportunity to grow into big businesses. And that takes time. Growth takes time. When they're big enough, they're like children. We can send them off in the world to compete. But when they're small and young, we need to nurture them and we need to protect them. So that argument is often used for protectionism, why we don't want to participate so immediately and rush into international trade and competition when we have these small industries. And then on the right-hand side, this broken ladder represents what we call historical imbalances in opportunity between North and South, or West and East. And the idea here is looking back 150 years or 200 years since the Industrial Revolution. The way North America and Western Europe have developed to become so powerful, so economically successful, so industrialized, and so advanced is through copying. Through free copying of technologies. Things are invented in one part of the world, they copy it and recreate this knowledge, recreate this capacity, learn from it, and build businesses in this sense. So these countries had a history of copying technology and growing into very strong economies. And now in the 21st century, the entire world must operate under the same international trade rules, including patent protection for technology, which means this kind of open copying is not anymore allowed. So Western Europe and North America had these economic opportunities 200 years ago that developing countries don't have now. So there's a historic imbalance in opportunities. They had a chance to nurture their infant industries, and now they're big centers of advanced industrial commerce, but small, poor countries did not have a similar opportunity. So that is sort of an argument that from a development economics perspective of why some people are skeptical of international trade or having the patent system as part of international trade. Some small countries aren't ready for this. And to be more material in what I'm talking about. When we strengthen the national patent system, yes, it benefits local inventors, but it also benefits foreign inventors. Yes, it benefits the local economy, but it benefits foreign economies as well. And we're not able to discriminate between other countries and other inventors in terms of our own country. So the WTO rules, the concepts of national treatment, or most favored nation, say that we must treat all inventors equally. It doesn't matter what country you come from. So you can't say, I'm giving a 50-year patent to inventors from my country, but only a 20-year patent to foreigners. It's simply not allowed. So the more foreign patent applications we have means our local market space is monopolized by foreign firms. This seems to be against the idea of using the patent system to promote the local macroeconomy. So what is happening here? Why should small or emerging economies bother with a patent system if the patent system historically tends to more benefit industrialized countries? Well, first of all, the most important thing, reciprocity and protection. Under these international trade rules, if we want our inventions protected in the US and Europe, we need to protect American and European inventions in our countries. So if we want to use innovation to grow our societies, we need to reciprocate that. And that is built into the international trade system. Secondly, we can't just rely on other countries and other societies solving the world's technical problems, because lots of times the problem a country, a society, a community faces requires local inventions. Every country, every society has a social context, a cultural context, where only the people from that community understand the problems people are facing and are able to make inventions and patent inventions that can solve those problems. So just having foreign technology alone will never be enough for development. We need to promote local innovation, even if we're dominated by foreign innovation. And lastly, and the most sort of
relevant one for this macroeconomic perspectives is that when a foreign firm from a developed country comes into a less developed country, it brings what we call FDI and knowledge transfer. So FDI means foreign direct investment. A company comes into your country, it brings investment, it brings capital, it spends money, that money is circulated amongst the economy, it creates jobs, it creates taxes, and it benefits the macroeconomy. When it comes with this technology and it patents it in your country, we also assumably, in principle, have this process of knowledge transfer. When locals are employed in this company, that foreign knowledge and know-how and technical skills are transferred onto the locals. So the presence of these foreign firms not only is good for the macroeconomy, but it also builds our local innovation capacity. So we can then go on to be more knowledgeable, more technically skilled, and invent and patent our own things. So shifting here, and I think this might answer the question in the chat again. Besides all those challenges for developing countries of participating in the international trade system and the patent system, which seems sometimes unfair to developing countries, the international system has a lot of what we call flexibilities in patent law to make sure that every country is able to address its own public policy priorities. So in patent law, you're allowed under WTO rules to exclude things based on public order, based on morality. What is public order in one country is different from public order in another country. So the patent law can accommodate local ideas of what is public order, what is moral, and what are the cultural values of that country. Individual countries can choose whether they want to protect things like diagnostic and therapeutic methods or not. We can say, no, things like a surgical method are so important, all doctors need to access surgical methods. We won't allow one doctor to invent a surgical method and monopolize it. Some countries allow that, some don't. It's a flexibility that an individual country can choose when designing its patent system. When it comes to plants and seeds, WTO rules, the international trade system, has a separate kind of mechanism. We call it plant protection of plant varieties, PPVs. There's a separate agreement called the UPOV agreement dealing with these things. So you can choose to deal with this through the patent system, or you can choose some other system to deal with it. Again, the idea that, yes, there's one set of international trade rules for all of us to follow, but there are flexibilities each country can choose. And related to the question in the chat, when it comes to public health and medicine, we have specially designed rules for public health emergencies. So in the last 2 years, we've had the global COVID crisis, and we've had a lot of discussions on what is the role of intellectual property in accessing medicines to treat illnesses and things like vaccines. There was the thought that the richer countries are hoarding vaccines and the poor countries aren't able to access vaccines because of patents over those vaccines. But built into the international system, we have mechanisms to get around that. We say public health is so important. In an emergency, we have a legal mechanism to go around those monopoly rights. And to use the language of Abu Bakr's question in the chat, that is a mechanism in WTO law to prevent overprotection or monopolizing something that's an essential good. Because most certainly, something like a vaccine or life-saving medicine, a life-saving medicine is an essential good. Then countries can decide on exhaustion and parallel importation rules, meaning whether we allow importation into our country, something that has been patented in another country and patented in our country but produced in the other country. It's a bit of a technical thing. I believe that you discussed that in this morning's session. But the point is that this is a big decision for a country to make. When a country is deciding on its patent law, it decides on an exhaustion rule and whether it allows parallel imports or not. And this is a big decision which affects how the patent system interfaces with international trade. Then we have the idea of utility models. Utility models aren't very popular in the big industrialized countries, but they are popular in smaller developing countries. Because in developing countries, utility models are used for what we call incremental innovation. Things that aren't big innovations that would justify patents, but smaller inventions. Sometimes utility models are called petty patents for this reason. So in countries which don't have that big innovation capacity, utility models can be useful. And international trade rules say nothing about utility models. You can have a utility model system or you can have not. So even though international trade law is quite strict with what you have to do in implementing a patent system, the point is there are all these flexibilities for public policy and all these decisions a government and a legislature needs to make when designing its patent system. And all these things have major effects on international trade, economic development, and of course the macroeconomy. So moving on to a very important question. What is innovation? We talk about innovation and it's this very abstract thing. We want innovation because it's good for the economy. We want innovation because it's good for science. What does it actually mean? Well, looking at this chain here, we have R&D. We invest in research and development at a university, at a lab, at a research center. And then some of that investment results in output. Some of that R&D output is patentable output. Then some of those patents are successful. Remember, a lot of patent applications are simply rejected. They did not meet that criteria of being non-obviousness and novel. Then out of these successful patents, only some patents are successfully exploited. Remember, we talked about most patents are abandoned in the first 5 years. Most patents remain unexploited. And that successful exploitation contributes to the macroeconomy. So going from conceiving of what we mean by innovation and going from investing in R&D to actually contributing to the macroeconomy, there are lots of steps here and there are lots of assumptions we make. Because the reality is not all R&D investment yields results. If you work in a science lab, not all your experiments yield usable results. R&D output will always be of scientific importance because it adds to our knowledge of what works and what doesn't work. But not all of that investment actually results in new knowledge. Then, not all research output is patentable. A lot of the research output that we produce, again, is very important for science, very important for education, but it might simply not be patentable because it's not patentable subject matter or it doesn't meet that criteria of being non-obvious. Then lastly, not all patents, as we know already, are successfully commercialized. The majority of patents just kind of fall by the wayside and are never really used. So when we try to measure innovation and we're saying innovation is important and therefore the patent system is important and therefore we want to encourage patenting, we need to be careful because focusing on patent statistics alone does not give the full picture. And the truth is if you're working in an R&D lab, and maybe some of you face this, you have a lot of important output which is of scientific value, but your investors or the government ministry which is funding you wants to see tangible output. They want to see a patent. They want to see commercialization. They want to see a measurable return. But not all the return on investment is measurable. And not all innovation is measurable, even though it might still be beneficial to society. So focusing on patent statistics alone does not necessarily give the full picture. So we have lots of different indices and lots of things we can look at to understand how a country is doing in terms of innovation. This first one here is called the Doing Business Index. It's by the World Bank. And it talks about the attitudes and perceptions of a foreign company choosing whether to invest in your country. How easy is it to do business in a foreign country? Why is this relevant to token patents? There's two important things here. Are registering property, which includes, intangible property rights like a trademark and like an industrial right, whether that's a design right, a patent, or utility model. Then, when we have a patent and we license it, a patent license is a form of contract, but that is not useful unless we're able to enforce a contract. So when a country is looking at whether it should do business in a foreign country, meaning whether it should not only patent its technology in a foreign country, but invest, start a factory, expand into the market, bring its foreign direct investment, bring its workers, bring its knowledge transfer. It looks at how easy and difficult it is to register property and how easy it is to enforce contracts. And both of those things are directly relevant to the patent system. We want to make sure the patent system is working well, where people have effective means of registering their rights and enforcing the way they contract those rights through licensing agreements. A much more useful tool for us, however, is the WIPO Global Innovation Index. This is a great study done every year by the World Intellectual Property Organization, which really measures innovation. And this is important because innovation is this abstract idea, and we say innovation is important, and politicians say, yes, we need to promote innovation, but what does it actually mean? WIPO has a very good process of creating a measurable index in how we actually relate innovation to things we can observe and measure. So two things I'd point out is human capital and research. And in research and development. So when we're looking at whether a country is innovative, we want to know, is it researching? Generally, the strongest economies in the world, very developed advanced countries, invest about 2% of their GDP in R&D. Less developed countries only, they invest less than 1%, sometimes 0.5% or so. So how much are we actually investing in R&D as a percentage of the national economy? That's an indicator as to how innovative we'll be. How many researchers we have employed, how our universities are doing, how much foreign corporate R&D we have. These things are very important. At the bottom here is what I would want to focus on because it's most related to the patent system itself. Knowledge and technology outputs. Again, these things are components of WIPO's Global Innovation Index. Remember, the goal here is to measure innovation because innovation is important for the macroeconomy, and understanding what patents have to do with measuring innovation. So knowledge and technology outputs. The creation of knowledge. So we look at how many patents by origin, meaning the citizens of a country, people in that country, how many patents they're actually applying and being granted. Then PCT patents, that's the Patent Cooperation Treaty, the sort of international filing system managed by WIPO, how many patents we have through there. And we know that knowledge creation is not just about what you patent, because there's a lot of scientific research which is not patentable. So you also look at scientific and technical knowledge. What is a country's researchers doing in terms of publishing in scientific to actually be commercialized and have an effect on society? So looking at knowledge impact, we ask ourselves, well, how does labor productivity grow? Each year, is the workforce getting more and more productive or not? Because the assumption is that if we're innovative as a country, our labor force will be more and more productive. Our businesses, how much do they spend on software? Our manufacturing industry, what percentage of the manufacturing industry is high technology? Or what percentage of the manufacturing industry is low technology, meaning it still relies on manual labor instead of automated processes? All these things are things we can actually measure in the economy to have an understanding of how innovative the country is, and therefore the role patents are playing in innovation, and therefore the role patents are playing in the macroeconomy and developing the society. knowledge diffusion. We can look at our exports. We can look at the intellectual property receipts. If we not only have local patents, but our inventors are patenting in foreign countries, do we have licensing revenues coming from abroad back into local firms? If we do, it means we're very successful innovators because our local people are not just patenting in our country, but in foreign countries, and they are licensing that technology in foreign countries, and that money is coming back into our local economy, creating jobs, creating taxes, and building and developing our society. What is the point of all of this? The point of all of this is that we say patents are important for innovation. Then we say innovation is important for the economy. But all these things are very abstract. And what we're trying to do is just measure these abstract things so that we can manage the policy. We manage the policies, manage the way we make rules and laws and make economic decisions as a government, as a regulator, as a state, as a research institution, in order to make sure that the patent system is doing what we want it to do, which is produce innovation, and not only just any innovation, meaningful innovation, which contributes to the national macroeconomy. So there are a bunch of numbers on the screen. Don't be intimidated. I'll explain what this means. It's just some statistics. We're talking about very kind of abstract things. It's nice to take some examples. This GII is the Global Innovation Rank. So just WIPO ranks all these countries in terms of how innovative they are and their actual score. So a few things I just picked out and put in this table are what we call GDP per capita, which is a measure of how rich a country is. The patents by origin, meaning how much locals are actually patenting in that country. And then the last column here, gross R&D expenditure as a percentage of GDP. How much a country is actually spending on research and development. So a few things I'd like to point out to you. Look at those top 13 countries. Each one of those countries are what we talked about earlier today, the IP5. Remember, we said that the 5 most important IP offices, which represent the majority of the global patents, right? The European Patent Office, US, China, Japan, and Korea. All of these 13 countries, because remember, the European Patent Office represents Switzerland, Sweden, Netherlands, all these European countries come under that. So all these 13 countries are those 5 offices, except for Singapore. So those big IP offices, which are so active and so important for patenting, all of those countries are the top countries in the world in terms of innovation. But at the same time, we shouldn't generalize too much. The other observation here, most successful countries invest at least 2% of GDP in research and development. We want to encourage expenditure on R&D to be innovative. And all these successful industrialized countries have at least 2% of expenditure on GDP. So if you want to measure your country, look at your country's statistics and its macroeconomic statistics and how much it's spending on R&D. Because if we want to be innovative, we need to spend on research and development. So 2% is kind of that rule of thumb of like what's a benchmark we're trying to aim for, right? Then let's compare these big Asian countries, right? These very innovative Asian countries, Korea, China, and Japan. Korea is just really, really active. They're spending most in the world on R&D, 4.6% of their GDP on R&D. And they're producing, very, very high numbers of patents. But let's compare China and Japan. China spends 2.2% of its GDP on R&D, while Japan spends 3.2%. So Japan is spending more money per capita on R&D. Yet China is producing more patents. Why is this? More R&D does not necessarily mean more patents. There's certainly a cultural dimension here. And I think this is part of this 3-day training program you're taking. It's inculcating this culture of the importance of patents, and not just the importance of R&D, but how we integrate patent applications into our R&D processes as researchers. So more R&D does not mean more patents, but there's definitely a role for what I would call a patent culture here. I find it quite interesting to look, just looking at just some examples from the region we're concerned with, to compare just picking out two countries, just to have a conversation. Comparing Iran and Jordan. Iran and Jordan both have, a similar GI score. They're similarly innovative. They both are similar in terms of the level of development in GDP per capita that measures how rich a country is. And they both spend about the same on R&D, right? Jordan spends 0.7%, Iran spends 0.8%. But Iran is producing so many more patents here, right, compared to Jordan. Again, this question of the patent culture, or how easy it is to access the patent system, or how knowledgeable people are about the patent system. So I'd be interested to hear from some of the friends and colleagues from Iran as to what you think some of the factors are at play here and why Iran, out of everyone in the region, seems to be doing so well in terms of boosting its patent culture and its patent portfolio. So it's a very interesting thing. So my goal with this slide here was just to show you where some of our countries are compared to the top countries in the world, and how to interpret some of these statistics, and how to also be cautious in not drawing too much inference from those statistics. So I would invite all of you to go into the WIPO Global Innovation Index report and look at the section on your country and check out those statistics and see what you can learn about your own innovation environment from that. So my last slide, my last thing I want to talk about is just a bit of a different conversation, but if we're talking about the economics of patents, there's one last economic aspect I'd like to talk about, which is the economics of patent administration itself. We're talking about building a patent system, and we've talked about today how the patent system has microeconomic and macroeconomic impacts. But administering the system as a whole is very costly, and it's normally funded by patent and trademark fees. So you have a national IP office, it might be an independent office, it might be an office in the Registrar General or in some government ministry. But the point is it's part of the government infrastructure. And it's very costly to administer. It's a lot of paperwork, it's a lot of staff, a lot of skilled patent. Examiners tend to be overworked and underpaid in many countries. And this whole system is funded by patent and trademark fees. So the system as a whole, and by system I mean the patent laws of a country, the procedures of your National Patent Office, and any case law from the courts, all these things come together to form a patent system, and that determines the threshold of patentability, or how we interpret these standards of novelty, non-obviousness, and utility. And those standards are different in each country. In some countries, it's very easy to get a patent. In some countries, it's very hard. So the same invention might get a patent in one country, but not in another, because the standards are different. And that standard is really a matter of how much we invest in examining the patent, how rigorous our examination is to make sure that this thing really is non-obvious and it really is non-novel. So when substantive examination is weak, the country might be producing patents, but those patents aren't necessarily that strong. They're not necessarily that valid. So validity questions still come up and are passed to the judicial system. So what I mean, if you get a patent in a country like Korea, it's very strong. The office invested a lot of money in making sure that patent is valid. So if a competitor finds that they don't like your patent because it's kind of making it hard for them to compete, they wouldn't be so quick to challenge the validity of that patent before court, because the assumption is a patent from Korea is very strong. In very small developing countries, the national office doesn't necessarily do all this work in examining the patent, which is very costly. We have, in some cases, unfortunately, what we call mere registration systems. So we don't do a substantive examination. We just do a formality examination. All the names are right on the paperwork. Everything looks good, it's complete, and we register this patent. Now, those patents are very weak because we don't know if they're really non-obvious or they're really novel. So if a competitor has a problem with that patent, it's very likely it takes it to the court. What is the point here? How much we invest in patent administration determines how strong the patents we produced are. And where we produced weak patents, we're passing that cost on to the judicial system. So it's not that the costs disappear and you just, any application, you just stamp it and say grant all those patents. You're creating more costs for the judicial system because it means you have all these questionable patents circulating, and that when there are conflicts between competitors, the courts now need to step in and examine whether these patents were valid or not. So this creates a very important thing. We talked about innovation ecosystems and how it's not enough just to strengthen the patent system. We need financial systems. We need entrepreneurial systems, all of that. When it comes to the patent system, strengthening patent administration necessarily means strengthening the judiciary, because you always have this relationship between the National Patent Office, which grants patent rights, and then the courts, which enforce those patent rights. So if we want a strong national patent system, which contributes to economic development, we always need to strengthen the judiciary. So when we're training and we're learning about patent rights and how they work, we want to train lawyers, we want to train scientists, we want to train business people, but also our judges and the people working in the courts. And that is why a strong, independent judiciary with well-trained judges is another very, very important of patent administration. So that's just my last slide, kind of talking about the economics of patent administration. I think I've been exactly 1 hour and 40 minutes, which leaves us some time for questions, but I'll just take my concluding slide now. And I know this was a lot of information. I know some of it was very theoretical and high level. I hope it wasn't too much, but just to kind of conclude, I would conclude with these 4 points. Microeconomics, well, the rationale for patents is to incentivize innovation, disclose innovation, and commercialize innovation. And we do that by providing a limited monopoly right. Then, society benefits from new products and increasing the stock of technical knowledge when we have a patent, at the cost of short-term distortions to competition. So there's always benefits to patents, but there's always a cost too, and we need to keep that in mind. That's a microeconomic lesson for us. In terms of the macroeconomics now, well, at the macroeconomic level, improved patent protection is generally, and I say generally because, you know, we're generalizing here, is generally associated with economic growth and improved international trade. Why? 2 things. Local innovation, pushing business, pushing development, pushing technical solutions. But then foreign innovation, allowing foreign companies to enter into our economy, bring in FDI, foreign investment, and knowledge transfer. So the macroeconomic benefits of the patent system operate on those 2 simultaneous levels: local innovation and then foreign investment. And those are 2 things we want to manage simultaneously and balance. Then lastly, very important, successful innovation requires an entire ecosystem across society, which a patent system is just one element. So you're spending these 3 days talking about the patent system and learning about the patent system, but then we also need a strong education system. We need a strong judicial system, and we need a strong financial system to ensure that companies can take these patents and actually commercialize them. So that brings me to the end of my presentation. I hope you found this useful. And I hope that, you can now use this knowledge about the micro and macroeconomic aspects of patents to kind of paint a bigger picture for everything you learn in the few days. Great.
Thank you so much, Dr. Khan. It was so useful and helpful. Actually, we really enjoyed the topics you shared with us. I hope the participants also feel the same with us.
Thank you. It was a pleasure. So I have, there were two questions in the chat. I'll just read the first one, which was from Mr. Abu Bakr. I think we went through this already, but I'll return to it. Is there any role the WTO plays in ensuring that overprotection of IP in member countries does not lead to protectionism or monopoly in marketplace for essential goods? And my response to that are there two things. On the kind of direct national level, we have a role for competition law, particularly when it comes to something like a standard essential patent. And then secondly, in WTO law, we have this mechanism for compulsory licenses, especially for public health emergencies like COVID, but it also applies for things like national security. Like you can bypass patents if it's necessarily for national security and protecting a country from war. So there are mechanisms in the WTO rules to provide that balance. Hope that answers that question. I have another question from a colleague from Malaysia. The question is, how does a patent owner determine the best price for their patent? This is a very tricky question. This is a separate field we call patent valuation. So there's this whole science of valuating IP rights, copyrights, trademarks, and patents. And you normally have specialized consultants who know about markets, and they look at comparable patents for similar technologies in similar countries and determine what, if you license this patent, what the likely revenue stream would be from royalty. Because when you're licensing a patent, you want to know what royalty rate to calculate it at. So there's a special skill, a special expert called an IP evaluator who does that. This like specialized accountants essentially. And on top of that, we add in a set of specific factors, which is not just how valuable your patent are, but your negotiating capacity. If you're a very small firm, it's hard to negotiate. If you're very big, successful companies with a whole team of lawyers, you have more negotiating power. So negotiating power depends on the size of your company, how much expertise you have in negotiations, and as well as the country you're coming from. If you're from Iran and you're negotiating a patent license with a company from the US, something just like the exchange rate will give the American company a lot of negotiating leverage because the American dollar goes a lot further economically than the local currency. So economic factors will come into play there. But the simple answer to the question, it's a specialized field called IP evaluators, which are specialized accountants, which calculate the best price for your patent. So I hope I answered that question. I am open if anyone has any other questions or comments. I think we have a few minutes. You can feel free to turn on your mic and ask or write in the chat. No? Is everything clear? I hope it wasn't too much information. Okay, well, I don't think I see any more questions or comments, but I'm not sure if the organizers are circulating these slides. If you want me to, I'll send these updated slides, and the organizers, you can feel free to give my email address to everyone if they wish, and we can keep in contact. Great. I just have a general comment. Thanks for your explanation and sessions. Great. Yes, so thank you so much. And I just really want to thank the Islamic Network of Science and Technology Parks. I really mean it when I say that the Islamic world has a special role in the global economy. The Islamic world is responsible for some of the greatest scientific, technological, medical, and mathematical developments in the history of human civilization. And we need to carry on this tradition. And hopefully throughout these days, you learn about what the role of the patent system is in carrying on this tradition. So thank you so much. It was a pleasure to be here, and thank you to the organizers again. So I return the floor.
Thank you so much, Dr. Khan. We've also shared the same with you, and I hope we can meet again in future sessions, of course.
It will be a pleasure. So to everyone, thank you again, and have a lovely rest of your day and a successful other 2 days of this conference and training session. Okay.
Thank you so much.
Goodbye.
For everybody, the participants, I have shared the slides and the speakers' biographies in the WhatsApp group that we have made. So you can go there and download it, and I will have something else to share about the test. The test will be not held on Thursday, it will be on Saturday, and I will share the exact time with you also in the group. Okay, thank you everybody for attending today. I hope I see you tomorrow for the final day, and have a nice day. Goodbye.